Lordship, this matter may be taken up on 27. Connected matter is fixed on 27. Your Lordship, WPC 835 of
19. It is submitted that the connected matter WPC
835-23.
835 of 2023 is fixed on 27th of March 27-3. Please this matter accordingly on 27th March.
May I please, Your Lordship? Lordship, I beg to mention a listing of WPC number 5409 of 2020
For
motion.
2020 matter, motion.
Yeah.
Take instructions.
Lordship, sorry, pardon, orders.
What orders do you need? What is the matter about?
Orders, here the petition got allotment of the fishery from BTC, Your Lordship, BTC joint director. But after that, one Nipen Haldar, Galdar.
You're not supposed to have the elaborate facts. Make it a mention ours. Tell us what is the urgency? Why do you want the matter to be listed for orders?
Because according to the deed of agreement through which he got the allotment, it will expire on 4th September 2023, Your Honor. But the allotment was arbitrarily given to another person through respondent number.
What is the stage?
Respondent number 6.
Is there any stay order?
The stay order, no, interim order was there.
Then what is the difficulty?
Difficulty, Your Honor, the deed of agreement will expire soon, September.
You are
So by
protected
that
by an
the matter
interim
will
order.
be invalid, Your Honor.
Protected by the interim order. When do you want?
28th March or
You have it on 31st of March.
31st of March. Public.
May I please, Your Lord? But I am playing for listing and application, my lord. I am, my lord. We
I
have
have for?
my lord. We have filed a writ petition, my lord.
I have for what?
I have my lord.
Implement.
Observation because, my lord,
Interim orders.
lordship.
When do you want?
My lord, tomorrow, my lord.
Tomorrow. When did you file?
My lord, it was filed in the month of December and listed twice due to paucity of time.
Monday.
Right.
Monday's date.
My lord, with the consent of other side, I beg to mention item number 37, madam.
Hmm.
My lord, a senior counsel, TJ Mohan to appear, madam. Maybe adjourn for 2 weeks. Or 3 weeks, madam.
Inform the other side.
Yes, madam.
On the prayer made on behalf of the petitioner. Best doctor. 3 weeks.
3 weeks, madam.
Yes.
Madam, all right.
May it please your lordship. Lordship, with the consent of other side, I'd like to mention item number 52, lordship.
5-2.
Yes, your lordship.
Supply list.
Yes, your lordship.
Yes.
Lordship, it can be taken after 3 weeks, your lordship.
After 3 weeks.
Yes, and lordship, there
The
was
motion matter.
lordship. We have not received instruction as yet, your lordship.
Who are you?
Lordship, I am for the respondent of 1 to 3. But inadvertently, lordship, we have written in the Wakal for 1 to 4, your lordship.
You are supposed to 1, 2, and 3.
Yes, your lordship. 4 is a separate entity, lordship.
It's for motion. Who's for the petitioner?
Sir, Fukan, R. Fukan is there. I've taken his consent, lordship.
Motion matter of 2012, 22. Adjourned by 3 weeks. Why?
Lordship, on the last, on
We
16.
issue notice of motion. Friday. Friday. Today we'll accommodate you.
Lordship.
I'll tell your colleague on the other side Friday.
Okay.
On a prayer made on behalf of the respondent numbers 1, 2, 3. List matter stand adjourned to be listed on 24th of March. Item 52, huh? For motion. Yes.
I beg to mention my listing of the case, my lord. Here, my lord, this petitioners are the petty vendors who were selected by the GMC. And
What is the stage of the case?
when admission stage, your lordship has passed an order to vacate this space, but they have not given. Outsiders still there. So one line order is required.
Next week, can edit. Next week, can edit. Okay.
For motion on Friday, madam.
Is the Bharat filed?
Yes.
Wait, please, your lordship. I beg to mention item number 58 of supply list.
58.
Kindly update the matter and 2 p.m.
Motion matter.
today.
Upgrade is not possible, motion. If it reaches, it's okay, otherwise not possible.
Lordship,
Not possible, all matters are important. It is at the motion stage. Yes, next.
Lordship,
What is the stage?
Lordship, and,
What is the matter about?
matter mining permit. Lordship, allotted the operation
Proposed not operate. And the
What is your prayer in the writ petition?
lordship, allow us to operate the mining.
The next Wednesday.
Please, your lordship.
Your lordship, I want to make a mention in item 23 of today's list.
It's a motion matter.
It's a motion matter, Your Lordship. I'm actually traveling. I have a flight to Delhi at 6:30 p.m. And this matter is urgent because it involves violation of fundamental rights of my clients in Article 17, 19, and 21. So my only humble request is, Your Lordships, may please take this matter at 2 o'clock.
Upgradation not possible. Will reach. You can leave this court by 3:30. We'll
Okay,
ensure
Lordship.
that, okay?
Please, your lordship.
Your lordship, I'm praying for listing of a writ petition. And it may come up
For
orders,
motion,
for orders.
what is the matter about
Matter about land compensation, land acquisition.
land acquisition? What is the urgency? Okay, next week, next Friday, not this Friday, next Friday.
Please, Lordship, I'm on behalf of MS in Havelia. I would like to withdraw item number 13 as there is a settlement between.
What is your name?
My lord, N. Kalita.
You are not signed the Wakalatnama. Yes, who is for the PNB? PNB, Mr. Ganguly. A. Ganguly. You are there in this matter? Item number 13.
Yes, my lord.
You want to withdraw? Is there any out of court settlement?
No, my lord, there's nothing because, yes, in fact, what has happened is that there was
Let them
some.
withdraw.
Let them withdraw.
MSN Kalita, Learned Counsel appearing on instruction of MSN Havelia, Learned Counsel for the petitioners, submits that there is instructions to withdraw this writ petition. Full stop para. 3A Ganguly, Learned Standing Counsel PNB. Higher education, anybody? As well as MS PR Mohanto, Standing Counsel Higher Education are present. Para. Writ petition accordingly stands dismissed on withdrawal. Yes. Madam,
Yeah, please. I'm praying for listing of a matter for tomorrow, my.
Tomorrow?
My lord, there is urgency in this matter.
motion matter.
Motion matter, my.
What is the
My
urgency?
lord, here, my lord, in this case, my lord, day after tomorrow, my lord, the election with regard to Kherkata Cooperative Society is scheduled. My lord, for the date of, from the date of notice, before the date of nomination till 20, the petitioner are continuously making application, showing that the voter list that was prepared, my lord.
Okay, we'll have it tomorrow.
My
Have you
lord,
filed or not?
My lord, I have the filing number 3396.
Okay, bring it. Inform the other side, Mr. Radudar will be there.
My lord, I will. Mass of bless, high
Okay.
bless, my lord.
Lordship, I beg to mention for listing of a WPC item, not listed for very long time, last posted on 11/12.
What is the subject matter?
Non-compliance of order passed by Honorable Assam State Human Rights Commission.
Non-compro, what was the order passed?
Lordship, Honorable Assam Human Rights Commission, by the order dated 12/3/2020, had recommended the matter to the Director of Handloom and Textile and Pragjyotis Industrial Weaving Corporation Society by directing to pay the entire use of the petitioner, including the terminal benefit of 4 months. But till date, it has not been paid.
When was the order?
Pardon?
When was the order? Please, please.
Order was on 12/3/2020.
When did you file the writ petition?
This was filed on 4/8/2021.
Okay, next week, give a date. Give a date in the next week. Don't keep Tuesday and Thursday. Yes, Galas?
It's a petition 5018 of 2020 lodging. Last listed on 3/6/2020. So with regard to a construction of drainage system in Gwalior town laws.
Construction of a?
Drainage system.
Okay, next week, any date.
May I please? Lord? It is item number 45. I'm appearing on instruction of KD Upadhyay, my lord, of Station Council.
Hmm.
Here, my lord, he is assisting senior counsel, Mr. Saiwala.
Hmm.
My lord, similar analogous matters are listed on 26th of April,
45.
my lord.
45, his name is not there.
His name is
Mr. P. Mazumdar is there.
KD Upadhyay is on all the 5 matters. He is the outstation counsel.
No, understood. Neither his name is also not there. Item number 45.
Yes, my lord. Ordersman.
Ekta Shakti Foundation,
Yes, my lord.
KD Upadhyay, for whom?
Petitioner, my lord.
P. Mazumdar. His also, his
His
name is
only
also
name
not.
is, P. Muzumdar's name is only reflected.
KD Mazumdar, KD Upadhyay is also not there.
Yes, my lord. His name is not reflected, but he is the council. He's assisting in Mr.
No, that is okay. But the other council there, you've sent the cause list.
Yes, my lord.
Now, we don't have any difficulty making a representation on a council who is on record, but Mr. Upadhyay is also not on record.
Somehow, my lord, his name is not reflected.
What about the other council?
P. Muzumdar, I could not get to it. Inform Mr. Saiwala yesterday.
Now, which matter he is assisting, the senior?
Item number 45, my lord.
And the others are connected?
Yes, my lord. And all these are analogous matter, my lord. Tender.
Inform the other side, all the
Yes.
council. Okay. When do you want?
26th of April, my lord. All are met.
Why elementary education here is there?
My lord, tender midday
Okay,
meal. scheme,
tender,
my lord,
okay,
tender.
A prayer has been made on behalf of Sri Saiwala Senior Council for the petitioner for adjournment.
Madam.
When do you want?
26th of April.
As agreed, as prayed for, placed on 26/4. This will be in item number 45, 46, 47.
No, my
and
lord, only 45, my lord. Yeah, IAs are connected with 45, only, two IA.
okay, whatever. Okay,
Much obliged.
45.
But I am listing for withdrawal. My lord.
Order has already been complied with.
Sri H. Bezburwa, Senate Council for the petitioner submits that during the pendency of this writ petition, the orders passed in WPC 7891/2022 have been complied with. Full stop. Senate Council accordingly prays for withdrawing this contempt petition. Full stop. Para? Contempt petition accordingly stands withdrawn. Stands dismissed on withdrawal. Stands closed on withdrawal.
It is your lordship. Also, it's an application under section 439 CRPC lordship.
Hmm.
And earlier rejected by a lordship. Offense under section lordship NDPS Act. The rejection order lordship will find at page number 94 annexure 8.
What are your grounds?
Lordship, as of now, he has been in custody for 515 days, 515 days, lordship. And lordship, 7 PWs have been examined. None of them have said a single statement against the present petition. And lordship, at this time, I am praying for calling of the scan copy of case record law, along with the status of the trial law.
Your name?
And Hassan law,
See, Mr. Hassan, we have made our position clear.
lordship.
If you are insisting this court to look on the evidence which has already been adduced, and we say something, if it goes against you, it will be highly prejudiced in the trial.
But in my humble submission,
You are taking a chance. Based on this, you said that nothing has been said till now.
nothing has been said.
Now, if we see anything else, because these are in the realm of the trial, not before us.
I understand. Lord.
For considering a bail application, we see a prima facie case against you. Now, somebody has said something against you. You said this may not be material against you. Now, if you hold the otherwise, then you will be suffering heavy prejudice.
But
If
then
a high court
observe-
makes an observation, even in a bail application, on the merits of the case, which we don't like to enter at this bail stage.
But lordship, that will be in my humble submission tentative to this. lordship.
Why tentative? You are referring to the evidence. You said that this evidence will not make out a case.
Lordship,
If we go with you, there's no problem. But then also that will be a problem. They will suffer prejudice. They said that it's our prerogative. Let us persuade the court.
lordship, not a
There's no restriction of you or bar to move an application for bail. But at this stage, don't refer to the. You can cite any other reasons. You are sick, somebody in the family is ill, somebody has died. These may be conditions.
In a case of commercial quantity, Lordship, detention is not the sole factor, Lord. So therefore, I am
Again,
submitting
you are
the-
going to the merits.
therefore, Lordship, in my humble submission, the twin conditions have been, Lordship, satisfied, Lordship.
Which what twin conditions in an
That, he is
NDPS?
not guilty of the offense, Lordship.
Is a matter of trial.
Lordship. That twin condition under section 37 NDPS Act, Lord.
The satisfaction is of the court that you are not, you
Lordship,
have not done the offense. How do you satisfy?
Lordship, in the
The onus is heavily upon you. It's a reverse.
Lordship, none of the witnesses have stated a single incriminating statement, Lordship. That is why I am, Lordship, submitting, Lordship.
That is not the end of the matter.
Lordship.
How many witnesses have been cited?
Lordship, in total, Lordship, may come to Lordship, page number 21,
How many?
charge sheet, Lordship.
And how many have adduced? 5. Total numbers.
Total witnesses 13, 1-3,
Hmm.
and 7 have been examined, and 8 examination is going on. PW8. And only, Lordship, official witnesses are there, Lordship.
Don't take a chance.
Other witnesses have been examined, and few of them have become.
NDPS, we are not too much. What is the amount?
Amount, Lordship, commercial 269 grams of heroin, Lordship. Just above commercial.
You are taking a huge risk. After 7 witnesses, if this court says, denies a bail, the court, trial court will definitely presume that those witnesses' evidence have also been taken into consideration. Okay, if you're insisting, we'll have the case, scan copy. Third, P.N. Hassan, Senate Counsel, for the petitioner who has filed this application under section 439 so. The Senate Counsel has submitted that on an earlier occasion, this court, by order dated 8/4/2022, passed in bail application 5/26 of 2022, had rejected the prayer for bail. Full stop. He further submits that in the trial, in the ongoing trial, out of 13 numbers of witness, cited witness, 7 numbers have already deposed. And as per the petitioner, there is no material allegation against him till now. What's the para? Call for a scan copy of the case records from the court of whom?
Additional session judge, Dibrugarh, Lordship.
Additional session judge, within brackets, special judge, Dibrugarh. In, what is the case number?
Is there, Lordship,
Special case number?
NDPS case number 55/2021.
In NDPS case number 55 of 2021. Full stop. Registry to issue necessary requisition for obtaining the said case records, scan copy of case records. Fixing Dibrugarh.
Dibrugarh, Lordship.
Today is,
Before Bihu, Lordship.
we'll have it on 11th. Is it possible? 11th of April.
11th, Lordship, on 10th.
Will be possible. Okay, let us see. 10th of April
10th of April.
2023. Sri V. Sharma, additional PP, is present.
Deeply obliged.
Praying for some time, Malab, to have a joint inspection, joint field verification.
Yes, Mr. Day. You need some time, Bunik? We'll grant short time.
Without disturbing this year's settlement. then considering this takes care of both sides on a fair submission, whatever it takes. Staying, shouting now,
How?
let it take 1 month, 15 days, 2 months, but without disturbing this year.
We'll give a short time. How much time do you want? 2 weeks. We'll fix a date. We'll fix a date. MS S. Sharma, London State Council submits that some time may be granted to enable the additional Deputy Commissioner Morigaon to submit proper instructions. Full stop. Para. List on 2 weeks before the Bihu.
No, people have to ferry through.
Huh?
Before the Bihu, it will be just on the DOP.
10th of April.
10th of April. That would
10th of April.
motion. Right.
How much?
Both the man.
Please, Your Lordship. My lord, here in this case, on the last occasion, some instructions were called from my learned friend. This is in relation to a plot of land in which, my lord, we are in continuous
Oh,
occupation.
Okay. MS G. Hazarika, Planning Council Revenue, praised for and is granted further 2 weeks time to obtain the instructions. 3H Burago Para, 3H Burago, Planet Council for the petitioners submits that there is an interim order which is required to be extended full stop para till the next date, comma, the interim order passed earlier, then extended.
I'm deeply obliged, my lord.
Mr. Roy,
The last date, Lordship, certain government
you
advocate.
filed your affidavit
I have filed.
for a delay.
Yes,
When?
I filed 10th of March. The last date, Your Lordship directed the registry to.
It was not here. Now it has come. It has come on record, yes.
Yes.
Yes, what do you say, madam? What is your explanation, Mr. Roy?
Lordship, my caste certificate, I belong to Kaivoto caste.
No, what is your explanation for delay? The cancellation was of 18.
So delay, Lordship.
Yes.
Delay, Lordship, it was never communicated to me. I have stated in detail. When
Where?
I appeared in a 107 proceeding, it was going on between me and my opponent who lost the complaint against me. That
No, where in the additional affidavit
Yes, Lord.
explaining the delay, where is your statement?
Lordship,
Not marked the copy.
Lordship, page, Lordship, 46, continuous page, 46, page para 3.
Hmm.
Para 3, Lordship, the deponent begs to submit the respondent number 3, district magistrate cum deputy commissioner, while passing the order dated 20th/9/18, cancelling the caste certificate of the petitioner for reasons based on to.
It was not communicated.
No, it was not communicated, Lordship. When my
Madam,
opponent.
what do you say?
It was stated or not.
Apart from that, interesting fact is, Lordship, my father is having the Kaivoto caste certificate. His certificate has not been cancelled, but I having his own son and my caste certificate has been cancelled without constituting the committee held by the apex court in Madhuri Patil case 1994 SC Lordship. ADC cancelled.
3 SP Roy, Senate Counsel for the petitioner who is aggrieved by an order dated 29/2018, by which the caste certificate of the petitioner as scheduled caste has been cancelled. Full stop. This court wide order dated 13/3/2020. This court had earlier directed the petitioner to explain the delay in approaching the court as the impugned order is of the year 2018. Pursuant thereto, the petitioner has filed an additional affidavit on 10/3/2023, wherein it has been stated that the copy of the impugned order was not communicated to him, full stop para. It appears that the guidelines laid down by the Honorable Supreme Court in the case of Madhuri Patil versus so-and-so report and so have not been followed prior to passing of the impugned order.
94 Lordship 6 SCC 241.
94 63 241. Para issue notice. MS S. Sharma, Planet State Council, accepts notice on behalf of respondent numbers 1, 2, 3, 4. What about Chairman, Scheduled Caste Development Board? No. Is it a government body? Up to 4. Let extra copies be served upon her by tomorrow. Let steps be taken for service of notice upon the respondent numbers 5 and 6 by registered post with AD. Steps by tomorrow.
Impugned order may be.
Stay at this stage.
Lordship, I am a contractor. I cannot participate, Lordship, due to- because
From 18 to 23, you are not affected.
recently I come to know, Lordship, my
The prayer for interim order would be considered on the returnable date.
obliged.
Madam, you can also take instructions on the delay part because he has said it was not communicated.
It was communicated to my opponent who lost the complaint against me, but it was not to me.
Communicated to respondent number 6, it has been communicated, not to you. We'll give a date, madam, returnable. Tell us, 4 weeks. Today is 22nd. 2, 3, 4. After the holidays, after the view on 19th.
Yes.
19th April, 4 weeks.
Obliged.
Yes.
The respondent number 5 issued an work order dated 10/3/18. And on 19/7/18, work order terminated. After that, I write a letter. Are you a bit settled? They are not a
Arbitration petition.
arbitration.
But your cause of action has arisen in 2018.
Yes, my lord.
How can you invoke an arbitration now?
No, my lord. We have preferred a writ petition earlier,
Earlier,
19. But petition was closed.
where have you stated?
Annexer, my lord. Like the last page, my lord. Page number 25.
That was dismissed for default.
Yes, my lord.
It is not dismissed on the ground that an arbitration clause is there on the availability of alternative remedy. That is not the fact.
No, my lord. After that, liberty is granted, my lord, to the petitioner to approach this court again if cause of action still survives.
If you have not come to this court for the cause of action, you have come for to issue notice.
Yes.
But there is negligence on your part apparent.
Yes.
What is your name?
Peter Lugdar.
P. Talukdar.
Yes,
You are not on record.
I'm behalf of Arfu government.
Why don't you sign the Wakalatnama? What is the difficulty?
He's not available today, so
Heard Sri P. Talukdar acting on instruction of Sri R. Fukan, Senate Counsel for the petitioner, who by means of this petition has prayed for appointment of an arbitrator. Full stop. The dispute appears to be of the year 2018, and the delay has been explained by the Senate Counsel by stating that on an earlier occasion, this is our petition.
yes,
Earlier occasion. You have to find restoration. How is a new petition, right? We thought it was a writ petition. Final restoration, we restore it. Okay. Hold on. Of the year 1980 and our petition 4 of 2019 was filed, which however was dismissed for default on 21/11/2022 with a liberty to approach this court again if cause of action still survives. Full stop. Para. Under those facts and circumstances and the fact that the earlier petition was dismissed for default, comma, this court is of the opinion that instead of a fresh petition, comma, an application for restoration would be the appropriate cause of action, would be the appropriate remedy. Full stop. Para. In view of the above, comma, the instant petition is closed by giving liberty to the petitioner to file appropriate application for restoration of the earlier petition, our pet number
Probably
4 of
19.
19. Yes, next.
Like,
Mr. Mazumdar,
My lord, order at page lordship, page 11. And they've also communicated the order to the authority, that is at page 12.
what was the direction?
Direction lordship in view, that is at page 11, lordship, para 7,
Examine the
lordship,
ex gratia.
lordship, yes.
Art 3L R Mazumdar Learned Counsel for the petitioner who by this petition has alleged non-compliance of the order dated 25/8/2021. What about the delay? 2 months was given. When did you file this?
Lordship, it is filed March lordship 2020.
Huh?
2000
What is the limitation?
Limitation 1 year, but we.
But what?
Well, lordship, there is a change of incumbent and we made against a remainder to the authority. That is also lordship
So
kind.
that will extend your limitation. You know, 1 year is the limitation. 2 months was granted. This order had to be granted 2 months' time. You filed after 2 months also. The order, what is the date? 25/8.
Lordship.
Can it come in 25/8, 9, 10 in October 2022? Oh, I'm sorry. You know. Passed in WPC 4192/2021. Full stop. The petitioner has also submitted that representations were filed, followed by reminder, even after which nothing has been done. Full stop. Prior the application for drawing contempt proceeding has been filed beyond the period of limitation. Full stop. Therefore, keeping the point of limitation open, comma, let notice of motion be issued, returnable by 4 weeks. Steps for service of notice upon the respondent be taken by registered post with AD. Steps by tomorrow. The requirement of personal appearance is dispensed with at this stage.
Like Learned senior counsel, you can will argue the matter, my lord, on next meeting. For the time being, my lord, or
Time being we can do, but it go just after the motions.
my lord.
After the entire motions are over. Today we are sort of time. After the round is over.
Tomorrow, oh, yes,
Is there an urgency?
urgency, my lord, election, my lord, I have challenged the election procedure, my lord. Already
No
approved.
urgency. If there is no urgency, have it day after tomorrow or try it.
My lord.
How many motions are there? One is the motion. Police sir. Eight I heard.
Elections, my lord, are all. They have challenged it. That too much of this petition for this honorable. court.
Day after tomorrow.
My lord.
On the prayer made on behalf of the petitioner. Based on day after tomorrow.
Right.
Yes, next.
Obliged.
Wait, please.
Well, the petitioner, the Rayati Khatian, under the Pattadas, at page, your lordship will find in page 25. My lord, thereafter, the respondent, he makes a complaint to the deputy commissioner saying that they are encroachers, let them pay money, I will transfer the title. That is at page 28, relevant portion at page 29. That, madam, I have no objection to transfer my said plot of land legally, transferring my title to those encroachers if they are ready to pay me present market value of the same plot of. Thereafter, my lord, there was a report from the circle officer who says that the petitioner's tea plantation has Rayati in the total land. My lord, thereafter, we find objection, and my lord, the settlement officer cancelled the Rayati along with the patta of another person, that is Bhagavan Satyasi Trust. My lord, I am on two counts. First of all, my lord, Joint Settlement Secretary, Bodoland Territory Council does not have the jurisdiction. That is the settlement officer. And the another one is that, my lord, to cancel a Rayati, it should be civil court. And tenancy can be done through implied also under the Temporary Settlement Tenancy Act 71. It can be implied also. The ground is that no documents has been found. That is why. But the circle officer report is that that we are Rayati Khatians, and my lord, that is why we are before your lordship. My lord, my friend was to this instruction.
But specific queries were made, man.
Hmm.
With regard to the authority and the joint security. Was the impugn order the decision? But so far as the split schedule concerned, man, land and revenue, the transferred subject. Joint security is fully empowered to pass this impugn order. The executive committee, land and revenue.
Yes, land revenue is a transfer subject.
My lord, and another thing is that, my lord, as per the Assam
See,
Temple.
you are basing your challenge on two aspects.
My lord,
One is the jurisdiction of the authority who had passed the order.
my lord. And another one is that it can only buy through a civil court. That is grounds for rejectment of a tenant. And tenant can be also implied under the Assam Temporarily Settled Area Tenancy Act 70. Khatian is there, my lord. So by an order without a civil court, here it is that, my lord.
But you say you are a tea garden.
But I am a tenant, my lord, the circle officer also.
Tenant of whom?
Tenant of the Pattadas, that is the complainant. It is in the Patta, my lord. Your lordship will find page 20.
But can a company be a Khatian holder?
My lord, it is.
You have to be landless Khatian holder. What is the meaning of Khatian?
My lord, because we are that.
You don't come under the purview of Khatian holders.
My lord, your lordship will find, we don't come under the act. We don't come under that special one, my lord. It's not that who are excluded. Tea cultivation can be done as a Khatian, as a rent, on a basis of rent. Tea cultivation is there. And for 40 years we are there. 40, 50 years.
That's a
here.
different matter, but what is the meaning of Khatian?
That is under temporary settled area.
For the 71 Act?
71 Act. Landlord and tenant is there. Landlord means a person immediately under whom a tenant holds but does not include any government. And tenant means a person who cultivates or holds the land of another person and is, but for a special contract expressed or implied, would be liable to pay rent for that land to that other person, and includes the person who under the system generally known as Adhi, Guchidi and Gutia, Barga, Chukti, Bag, Tukami cultivates the land of another person on condition of delivering a share or quantity of such land to that person. That is a tenant. And my lord.
This is the concept is of sharing the crop. Crop means what? Adi is not commercial crop.
My lord, it can be in lieu of rent means, my lord. The rent
These are for landless people.
My lord, rent means whatever is lawfully payable or deliverable by the tenant to the landlord in cash.
Payment of rent is not the sacrosanct.
Because my lord,
only condition.
Circle officer also says, but my lord, in Kokrajhar there is a settlement officer, and my lord, there is an additional assistant settlement officer. Now, the secretary has passed that order. The deputy commissioner is the revenue authority. The complaint was made to the deputy commissioner. Now, where from the joint secretary comes? The complaint was made to the deputy commissioner. Assistant settlement officer is there and others are there. Now the joint secretary passed the order. Your lordship will find the complaint. It is to the deputy commissioner. Settlement officer is there. Wherefrom he usurped the power of the settlement officer, the joint secretary. And my lord, in the Patta land, my lord, both the name of the petitioner, both of the private respondent, another is that at page 25. And the number one, the serial number one, name of the Rayat, father's name, address, Lalpura Tea Plantation Allied Industry. And kind of Rayati right under possession.
Will you be a tenant under the 71 Act?
My lord.
Under section 317?
My lord.
My
lord. Tenant means a person who cultivates or holds the land of another person.
And the entire concept is to give land to landless people, Khatian holders, who have been cultivating land of others
because my lord,
on Adi basis.
Here, my lord, we are also, as a rent means, my lord, it can be cash in kind or in partly in cash and or partly in kind. It can be cash.
This matter needs to be delivered. I don't think this will be maintainable by this thing.
Because
you're a company.
Company, Lalpura tea.
Company, Khatian holder.
My lord, it
doesn't make any sense.
Tea cultivation, my lord, the name as it shows as such. But my lord, your lordship will find in the document that is the district Kokrajhar Assam Temporary Settled Area Rayati Right Act, page 25, your lordship will find. Assam Temporary Settled Area Rayati Right Act.
You're an artificial entity. You're an industry.
But the document is as such, because we are cultivating tea over there. At page 25, it is there, my lord. Specifically, it is there. It is a government document, my lord.
25?
So the original is at page 26.
This will need some deliberation.
My lord.
We will have it for motion either tomorrow or Tuesday next.
Next Tuesday, my lord.
After hearing P.K. Roy Chaudhary, Senior Counsel for the petitioner, as well as S.R. Rabha, Learned Training Council, BTC, this court is of the opinion that some more deliberation would be required, more so when the petitioner, which is what is your legal status? What is your legal status?
My lord, status as because I have been represented by your lordship.
No, we are not under representation. Who are you? Who is the petitioner per se?
The petitioner is my lord Lalpura Tea Plantation.
We
represented by
will see the
secretary.
name. What is this? Is it a company, proprietorship, partnership? What?
But my lord, it is, I think, my lord, it is not a company as such.
No, no, what is, you have to, if you come to the court, either a legal person or a citizen has to come to the court.
My lord, this is true.
Somebody
But it is
who
not a
does not
company.
have
But
any legal
what I
entity.
understand, it is not a company, my lord. It's kind of, it's, the name is nomenclature maybe at that of, but
We are not under nomenclature at all.
my lord,
What is it?
it is, my lord, like a group of persons. They have
Group
joined
of
together
persons.
to cultivate tea and my lord, sell that way.
You have not said you are an association. You say that
It
you are
is
represented by the secretary.
my lord, that is.
Secretary of what? Of an industry? Industry,
Lalpura Tea Plantation and Allied Industries, Dolmara.
industry
But
cannot.
it is basically that industry is the separate one, is different place. Lalpura Tea Plantation. We are basically on Lalpura.
Who owns the industry?
My lord,
Who owns the industry?
that industry, my lord, is owned by, my lord, because it is represented by a few persons that have joined together, my lord, and your lordship in the circle officers, EO's report at page 31, your lordship will find. EO's report, first paragraph, last line, few line. Further in column 9 and 10, in the Chitta, the said land is recorded in the name of Lalpura Tea Plantation, in Dhurmala as number 1 Rayat during the process of record.
Where are you reading?
Page 31, paragraph first from
Recorded now. No, we are not on what has been done
circle officers
in
report.
the office. We are here to know your legal status. Industry cannot come to the court. Industry is owned by somebody, either your company is owning or a proprietorship is owning or
It
partnership.
is kind of a group of persons, not a company registered on the Companies Act.
You file affidavit.
But we will file affidavit.
We will learn some deliberation. Full stop. This court has also noticed that the petitioner is one Lalpura Tea Plantation and Allied Industries. Full stop. On a specific query, comma, the counsel for the petitioner submits that he would seek instructions regarding the legal status of the petitioner and file an additional affidavit to that regard. Full stop. In that regard. Full stop. Para. Please for motion. Tuesday next or Thursday next?
Your lordship will.
Next you can file the affidavit.
We'll file by Monday, we'll file it.
Okay, then Tuesday next.
There is already an interim order that
Will you extend it?
will.
Have it on Thursday. List on when? 30th of March 2023. Para. Interim order passed earlier. To continue to the next date of listing.
Okay.
Petitioner filed an application before the concerned authority, my lord, for installation a stone crusher machine, my lord, at page.
Yes, instructions.
Instruction I have received, your lordship, it says that the complaint, this was reported by the panchayat members, the NOC, which was given, the crusher unit is not a genuine one alone.
My lord, fact is, my lord, actually fact is that lordship, kindly see lordship page 21, my lord. Lordship, my petition,
Expired.
lordship.
NOC has spent its force.
My lord, lordship petitioner, when the filed the petition, my lord, application before the Conservator Forest, my lord, at page.
G.V.N.M. Luskar, Learned Counsel for the petitioner who is aggrieved by a communication dated 17/2/2023 by which the activities of the stone crusher unit owned by the petitioner at Siberbond has been suspended. Full stop. Para. This court, by order dated 17/3/2023, had directed the learned standing counsel, Forest Department, to obtain instructions. Full stop. Sri R. Gogoi, current standing counsel, has placed before this court a copy of the written instructions dated 21/3/2023, from which it appears that the petitioner is without any valid no objection certificate from the panchayat.
And I have an annex, my lord. This petition I have an annex, my lord. My annex I have page, lordship kindly page 24, my lord.
The aforesaid submission, however, has been denied, disputed by the petitioner by submitting that the no objection certificate by the panchayat has been annexed as annexure number 3, full stop para. A perusal of the said NOC would show that it was of the year 2017, and the instructions is that the said NOC was not renewed. Full stop para. Be that as it may, or let notice of motion be issued, returnable on on 19th of April. NOC is for how many years?
Lordship, as per guideline, there is
Year
no-
to year or what?
Year to year, most probably.
Lordship, one lordship. So as per guideline, lordship kindly page 16, my lord. I have a next guideline, my lord. There is no provision, my lord.
Access notice on behalf of all the respondents. That extra copy be served upon Sri Gogoi by tomorrow.
No, next, my lord, collected all the NOC, my lord, to 1990.
Let's see, you file affidavit.
In the meantime, my lord. You know what I mean? Obligation. Obligation.
On the validative thing, you can substantiate your allegation, your contention that the NOC once granted is not required to be renewed. It cannot be. There has to be some tenure of an NOC. This is of 17. You take instruction from your client, there may be.
NOC, my lord, he submitted collection 17, my lord.
Yes, next.
Please, your lordship. The petitioner before lordship, they are members of a cooperative societies, my lord. My lord, elected members, my lord. Their tenure is for 5 years. That is correct. And their tenure is going to be complete in the month of April 21st. But my lord, in the meantime, my lord, due to interim order, the petitioner could not perform, my lord, 1 year. On this,
Interim order
by this honorable court.
in some other proceeding.
In some other proceeding. So my lord, 1 year they could not perform. On the similar issue, your lordship also stayed the election. But in my case, problem is that, my lord, we are to convene the meeting with election or without election. In this regard, we have filed a representation before the register.
The elections were not going to interfere.
No, not.
Primary elections were not
Yes,
going
that
to
is
interfere.
Our tenure is going to be complete in the month, April 21st. In the meantime, we have filed a representation there whether we will convene the meeting with election or without election. In this regard, a representation is pending before the
What do you
register.
say?
Well, this issue has been decided by the apex court, basis of which there is an order also. My lord, in the identical case, WPC 624922, department has filed the affidavit. So both the matters taken up together, that affidavit will cover this.
When is that case fixed?
In fact, my lord, that it was date not fixed, my lord, but returnable date, my lord, has already gone. So
Notice has
both the cases
been,
can be taken
we
up
can
together.
issue notice
Yes.
then.
Yes, ma'am.
A short date is, but because, my lord, we have to convene the museum with election or without
No,
election.
we'll have it allow with that case if the same issue is involved.
My lord.
Third, Sri N. Hawk Planet Council for the petitioner who is aggrieved by the inaction of the respondent authorities in considering a representation filed by the petitioner seeking postponement, seeking a clarification regarding holding of elections of the for the board of directors.
Fine.
Full stop. Three. Hawk, the learned counsel for the petitioner submits that due to an interim order passed by this court on 9/9/2021
Right.
in another writ petition being WPC 4457/2021, the petitioners were not allowed to function for about a year, for which reason they have submitted the aforesaid representation for extension. Full stop, para. On the other hand, Sri Talukdar, SK Talukdar and Standing Council Corporation Department submits that the issue involved could be covered by a decision of the Honorable Supreme Court, and in this regard, another writ petition wherein similar issues have been raised is pending consideration.
WPC
Being WPC
6249/22.
6249/2022, full stop, para. Let notice of motion be issued, returnable by 4 weeks. Sri SK Talukdar and Standing Council Corporation Department accepts notice on behalf of all the respondents.
My lord,
What about 6?
yes, 6 no, my lord. 6 secretary, my lord, I cannot accept.
Secretary, why not? Secretary
Secretary is the employee of the board, my lord.
of the board.
My lord.
1 to 5, extra copies be served upon him by tomorrow. Let steps be taken for service of notice upon the respondent number 6 by registered post with AD. Steps by tomorrow. Full stop. List along with WPC signs.
Well, our problem is that, my lord, board is going to be completed 21st of March, April, my lord. And they may, my lord, take action under section 39 to dissolve the board. That is the problem.
Can you fix a date before 21st of April?
21st of April. Or
Let the matter be listed along with Jagota Rikipa, along with so on your 31st of April.
My lord.
So you'll have it before. We'll try on 10th of April.
My lord.
10th of April. Anything? We'll finish the motion, don't worry. Yes.
For demarcation of my land, my lord. I'm a secretary of my lord, Auraghad, my lord, Santi Niketan. And for this, my lord, annexer, Kalinsi annexer 27, my lord.
Demarcation.
Yes, my lord.
We covered by the judgment.
My lord.
We already passed a number of
My lord.
orders. Where is your application?
At page, my lord. At page 21, my lord.
21 is addressed to whom?
To the, my lord, Secretary Department Revenue, my lord.
He is not the authority. Who is the authority?
The authority of the Autonomous Council Assistant Settlement Officer, my lord. Yes, of course. But lordship, if you lordship please on Monday, my lord, earlier there was a public interest filed in respect of that particular.
Is it? Okay.
My lord,
We'll have it
so
on Monday.
my lord. Next.
On the prayer of Sri J. Chutia, learned council, learned standing council, KAC, released this matter for motion on 27th, 3/2023, as on the said plot of land, as per his, on the same plot of land, there is another litigation pending.
That has been disposed of. Earlier, one.
Monday.
All right.
Wait, please, your lordship. Lordship, the petitioner is a farmer and his lands falls under the Karbi Anglong Autonomous Council. And he made a representation at page 24. Lordship, what happened just before the COVID lockdown, a part of his land was taken over by some officials of the Karbi Anglong Autonomous Council. And during the COVID lockdown, the entire land has been snatched away from him without considering the damages that have arisen out of agricultural activities or any other aspects. So therefore, after
How is it possible?
Peratian, my lord.
How is it possible?
Lordship, look at Peratian. He has stated that there was the office of the soil conservation is there. So apparently, my lord, it may be the government land, my lord. So may have some other part. Lordship, issue notice and
I being an illiterate person, I am not aware whether it is soil conservation office or not, but it was brought to my notice by someone.
Your name, M. Alam.
S. Zaman.
Art 3 as Zaman, learned counsel for the petitioner who alleges that is Myadipata land.
Lordship, it is
Myadipata land in the district of Karbi Anglong has been forcefully taken over. Full stop. On the other hand, comma, 3. HTR, learned standing counsel, KAC, by drawing the attention of this court to the averments made in paragraph 10 of the writ petition. Paragraph 10 submits that the petitioner has admitted our existence of an office of the soil conservation over the same plot of land. Full stop. Para. Be that as it may, comma. Be that as it. Issue notice of motion, returnable.
The Directorate of Land Records has been already been implemented as respondent number 2.
Soil conservation is also a transfer subject. He'll take care. Revenue, MS, T. Hazarika and Standing Council Revenue Department accepts notice on. We have a response numbers 1 and 2. State Council. The jury for response numbers 3.
4 to 10, I mean.
Chaitya for Standing Council, KAC for response numbers
4 to 10.
4 to 10. Full stop. Returnable question here. The notice is made returnable by 4 weeks.
Deeply applied.
Actually, the matter pertains to my lord deduction of toll fee, my lord, from my FASTag account. My lord, particularly, my lord, 2 toll plaza deducted money from my FASTag plaza toll account, my lord. And both the toll plazas are, my lord, situated at Gujarat at Rajkot district, my lord. And numbers of times, my lord, the fee has been, my lord, deducted from my account. My lord,
Which
in this
place?
figure, that was, my lord, one is, my lord, kindly come to page 20. One plaza is, my lord, Barodi, and another is Pithadia. Both are situated at Gujarat.
Now your deduction is from where? Did you happen to visit those places?
No, my lord, no, my lord. My car is, my lord, lying in my house.
How is it possible?
Yes, my lord. That is, my lord, kindly see the page 20, my lord.
Yes, who is for Transport Department? Whom have you served?
My lord, yes.
Who are the
National-
parties?
Indian Highway Management Company Limited. They are, my lord, under the NHI.
Yes, CGC, NHI. CGC,
My lord, Arbora was there, my.
Arbora,
Yes.
CGC. Please inform. Third, Sri S.A. Ahmed, petitioner appearing in person.
Yes.
Who is aggrieved by deduction of
Toll fee.
toll fee by two toll plazas in the state of Gujarat, in spite of the fact that the vehicle concerned has never been plied in those areas, in those areas. What's the para? How did you come to know about the deduction?
My lord, the SMS, my lord, short messaging. My lord,
The
case 20.
United Council has also
Against my
drawn
vehicle.
the attention to the print copies of the SMS received of such deduction. What's the para? Issue notice returnable by 4 weeks. MS, let her come. We'll give now to the MS. Arbora, Learned Standing Council. Ministry of Road Transport is not Ministry of Road Transport. Any CGC? Any CGC? Central Government Council?
HAI, this Ratul Talukdar.
NHAI is a different party. We have the ministry also, a party, or MRTH.
Yes.
Try to bring some CGC. Yeah? Three students accept notice on behalf of respondent 1 and three students for respondent 2. Extra copies be served by tomorrow. Steps for service of notice upon the respondent 3 and 4 be taken by registered post to TD. Steps by tomorrow.
Obliged.
You try to have one CGC. This is a very serious matter. We'll ask them to obtain instruction. Yes, next.
May I please, your lordship? Your lordship, the matter pertains to non-disposal of the representation submitted by the petitioner to the deputy commissioner. In this case, your lordship, what happened? My father was
Disposal of representation regarding what?
paying for handing over the position of the land measuring 3 kattha 19 lecha. My father was a right in respect of a plot of land measuring 2 bigha 7 lecha. Out of that, the government of Assam, by Gazette notification, had acquired 1 bigha 1 kattha 8 lecha land. So remaining land is 3 kattha 3 kattha 19
lechas.
So that land, they have not handed over the position of that land to me till date. Neither have they given any compensation to me.
Your name?
MBDL. MBDL.
Where is your name? We know you're not on record.
My senior is on Lexi.
Who's your senior? Ananja?
Ananja.
We know your name, Beria, but we are not finding your name here. Third, Sri M. Beria, appearing instruction of Sri N. Jha for the petitioner, who is aggrieved by the inaction of the respondent authorities in either giving back the portion of the land which was outside the purview of the land acquisition proceedings, or to pay compensation for the same, full stop. He submits that in this regard, representations have been filed and are pending, full stop. Issue notice returnable by 4 weeks. Three, Deori, London State Council, Revenue, MS, G. Hazarika. Standing Council Revenue Department accepts notice on behalf of restaurant number 1, whereas B. Deori, London State Council accepts notice on behalf of restaurant numbers 2 and 3. Let extra copies be served upon the London Council for the respondents by tomorrow.
Lordship, there is some discrepancy in annexure 4 translation, so I may be allowed to correct.
What is the problem?
Lordship, it does not make any meaning.
Which one?
Annexure 4, page 20.
20.
Yes, Your Lordship.
Good.
I may be allowed to correct.
What is the correction you want to say? Let us see.
Has requested for the sake of position over the, that should be has requested for handing over the position.
Bastens Mandal. What is this? Is not cut paste also. You use Dragon.
That Google text, Your Lordship.
Google text. Be careful.
Yes, Your Lordship.
Yes, do it.
Much obliged.
Do in both the copies and his copies also.
Okay.
Yes, next.
May I please, Your Lordship? The petitioner was appointed as chairman of VCDC Madati Lordship on 1903.
What is your name?
S. Ali Lordship.
No, petitioner's name.
Sukur Ali Lordship.
Same Sukur Ali.
No, my name is Sofikul Ali Lordship, S. Ali.
No, your petitioner's name.
Petitioner name is Sukur Ali Lordship.
The one, famous Sukur Ali.
Yes, viral one.
Yes.
Yes, Lordship. That
We will want him to have it in person. Ask him to come to the court and address.
Okay. May I, Lordship? Lordship,
He has his own language. He has developed English.
Yes, Lordship. Yes, Lordship. He's trying his best, Lordship.
You're also very happy.
Yes, Lord.
Interacting with him.
Yes. Lordship.
What does Sukur Ali needs from the court?
Lordship, he was the chairman of VCDC Lordship. So subsequently one
chairman of
VCDC of Madati Lordship. So Lordship, subsequently after completion
what is VCDC?
VCDC Village Council Development Committee, it's autonomous council Lordship. So Panchayat Raj is not applicable there Lordship. Instead of that, local bodies are formed.
Why Panchayat Raj is not available? Not applicable.
It belongs to 6th schedule Lordship.
Okay.
Lordship, now the earlier notification was superseded.
This point he has told you or you have told him?
I have told him, Lordship.
You have told him.
Yes, Lordship.
What is his grievance?
Actually, a new notification was come into existence and which
He was removed.
He was removed his post, Lordship. The both
He's only 29 years.
Yes, Lord.
Small boy.
Yes, Lord.
Yes, madam. Okay, we'll issue notice. Hard.
Yes.
Your S. Ali.
Yes, Lordship. I am
Part 3 S. Ali Learned Counsel for the petitioner who is aggrieved by an order dated 13/2/2023 issued by the Director of Panchayat and Rural Development, BTC, by which a new VCDC chairman has been appointed by removing the petitioner, full stop. It is the case of the petitioner that by an earlier order dated 19/2/2021, he was appointed as the chairman of the VCDC. Full stop para. Issue notice returnable by 4 weeks. MSN Bora Learned Standing Council, PNRD, accepts notice on behalf of respondent number 1. There will be an additional director in BTC. How can there be a director? One only, madam. One. PTC, MS, Sri, S.R. Rava, understanding council, BTC, accept notice on behalf of restaurant number 1, other 2, 3, and 4. Let extra copies be served upon the learned council by tomorrow. That step will be taken for service of notice upon the response number 5 by registered post with ED. Steps by tomorrow. 5 is the new second chairman.
Yes, sir.
Okay.
State level. as well.
Please, your lordship. Lordship, this matter pertains to demarcation as well as identification of a plot of land, my lord, wherein we have referred an application before the concerned circle officer. My lord, comes to page 30. Is annexed 6.
30.
Yes, my lord. Please, your type copy annexed here with my lord.
Yes.
Where we have prayed before the concerned circle officer so as to demarcate as well as identify the plot of land. So far as, my lord, the petitioners, they are joint title holders as well as possessors of a plot of land. Now, this plot of land, my lord, it is measuring about 4 bighas and 4 kathas and has spread over several numbers of dag, my lord, of special pata number, of special Miadi pata number 4, my lord. So, my lord, these petitioners have inherited this the said land from the Dikis Patadar by virtue of being class 1 legal heirs. And we have also annexed, my lord, the order conferring the mutation, which is at page 18, annexure 2, as well as, my lord, page 21, annexure 3, my lord.
Yes, demarcation. Should we dispose this of? In terms of his representation to be taken as an application under the Assam Right to Public Services Act 2012.
Right.
Okay. Your escolator.
PDAS, my lord.
PDAS. Part 3 PDAS, Learned Council for the petitioners. Also heard Sri P. Deuri, Learned State Council, as well as MS G. Hazarika, Learned Standing Council, Revenue Department, full stop. Para, considering the subject matter of this writ petition and as agreed to by the parties, comma, the same is taken up for disposal at the motion stage itself, full stop. Para. The petitioners, who are 2 in numbers, claim to be the owners in possession of a plot of land measuring 4 bigha, 4 katha, 7.4 lechas, covered by various dags under special patta number 1/27/4 at Poshim Jalukbari, Guwahati. Full stop. The petitioner's grievance is that in spite of an application which has been submitted to demarcate, to identify and demarcate the land, comma, nothing has been done, full stop. The Learned Council has submitted that the land has devolved upon the petitioners by right of inheritance and their names are also mutated, and the application filed before the Circle Officer Guwahati is dated 8/9/2022.
You also preferred an application before the deputy commissioner also, my lord, but to no effect.
The issue of demarcation can be redressed by taking into account the provisions of the Assam Right to Public Services Act 2012, under which an office memorandum dated 21/12/2020 has also been issued. First of the state OM based on a detailed procedure for demarcation. Full stop. Para. Under the aforesaid facts and circumstances, comma, the instant writ petition is disposed of by directing the circle officer, Guwahati Circle,
Yes, ma'am.
Guwahati Circle, to consider the representation dated 8/9/2022 filed by the petitioner and take appropriate action for appropriate action for demarcation of the land in question. Full stop. Para. The state authority is also required to carry on the same exercise by issuing notice to the affected parties and giving all the affected parties an opportunity of hearing. Full stop. Para. The exercise, as indicated above, be carried out expeditiously and preferably within a period of 4 months from the date of receipt of certified copy of this.
Obliged.
Petitioners, one second, Mr. Khalid, does the petitioner are directed to submit all further documents in support of the representation. Yes. Next. Next.
Lordship. The devoter matter, Lordship. The devoter matter, Lordship. Similar type says by the Senate.
Voters disposed of. Write down the names of the council.
Yes.
No, there's a different councillor there. Madam Al-Lebi.
In this case, page 58 of the NIT, page document issued by the Tezpur Municipal Board.
58.
Vernacular version. And but I am intending to bid for the item number 8, that is the Lichu Pukuri. This is the famous Lichu Pukuri of Tezpur, the spotted also. So this item number 8, and what I am challenging is the provision in clause 9, that is page 59.
Where is item number 8?
Item number 8, Lordship will find this part on Ekkalin. In
Page
that
58.
sense. Yes, 58. First, there is a list of 5 markets. Then
Yes.
of 8. Number 8, Lichu Pukuri, Lichu Aru Pukuri, that part. So this is the reserve price, etc. With that, I have no quarrel.
What is this market?
This is the Pukuri and the trees. The Lichu Pukuri of Tezpur and the trees which are on.
You have to maintain.
Yes, I am the lessee for the past 3 years. In fact, I have been there for the past more than 50 years.
And proceeds you will sell.
Yes, proceeds I sell and I pay the KISS money and the lease money to the board. The condition at page 59, Lordship.
This is on the way towards the university.
No, this is in the very heart of Tezpur town. Padam Pukuri, that part, near about that.
So while coming from the university near Purva Chowk.
No, not that.
Purva Chariali.
No, not that one. This is
not
the
the-
heart of Tezpur town.
Okay.
The Lordship will find
What is that place called?
So that is near the old ASAB office. It is near that RK Mission.
If you go towards the university,
That is,
Central University.
I have started to forget some names. But it is on the way to the, yes, Lordships are right. I understand what your Lordship is getting.
You go
It
from.
is opposite the Nikamul Satraman. Nikamul is on the left.
Okay. What has happened now?
Now, clause number 9, Lordship will find at page 59.
What is the proceeds you get from this?
Proceeds, we get by the sale of the lichu and the fish, in the pond. The clause number 9, Lordship will find on the very next page, that is page 59. উচ্চতম বা যিকোনো নিবিদা গ্ৰহণ কৰিবলৈ কৰ্তৃপক্ষ বাধা নাথাকিব যিকোনো বা সকলো নিবিদা কোনো কাৰণে নদৰ্শক অগ্ৰাহ্য কৰাৰ ক্ষমতা কৰ্তৃপক্ষ থাকিব নো প্ৰবলেম আধাৰ মূল্যতকৈ কম আৰু আধাৰ মূল্যৰ 10%তকৈ বেছি অধিক মূল্যৰ নিবিদা গ্ৰহণ কৰা নহব this is the only eligibility criteria 10% cap that means let us say the reserve price is 1.5 now if 1.65 there are more than one bidder. There is no provision in the NIT as to how that bidder is to be active. Nothing in absolutely silent as to how it could be selected. And Lordship will see the basic non-application of mine by the fact that Lordship will turn back to page 58 for a minute. The notice says that the forms are to be issued from
This is the fourth line I'm reading, Manoj, from the page 58. 20/02/2023 up to 24/3/2023 forms are to be issued and the tender closes on 27/3/2023. These are the dates, Manoj. So 20th of February to 24th of March. These are the dates. And Lordship will find the date of the notice, the NIT, Manoj, at page 61. The NIT has been issued on 14th of March 2023. Absolute violation of Rule 3 of the rules for the sale of pounds and markets, which provides that 1 month is minimum.
But what prejudice are you suffering? You are in no.
No, I am an intending bidder, my lord. Now, 10% cap, and I am willing. I have no difficulty in willing. But thereafter, my lord, how to select the procedure? Will there be a lot?
What is your cause of action?
My cause of action is that, my lord, there is no procedure in the NIT, absolutely silent on how the successful bidder is to.
Have you submitted your bid?
No, bids we have not submitted, my lord. The bids are closing. But now, my lord, the NIT being silent, lordships are aware of the number of judgments that there is absolutely nothing in the NIT.
At this stage, no interference. At best, we will get an issue notice.
My lord, but once the bids are accepted, then, my lord, the NIT is absolutely silent.
What procedure they adopt?
No, that has to be specified in the NIT itself, lordship. This Honorable High Court has held, the Supreme Court has also held, right after Datta Associates onwards.
How tender is to be finalized? They have the standard methods.
No, there is no standard method and there is nothing in
Why you are giving bids different parties? Can't they make out the best suitable bid?
No, that criteria has to be specified, my lord. Lordship will take up.
If they adopt any criteria which is not unknown to law, we will interfere. We cannot assume.
The Public Procurement Act of 17 and the rules.
What is your apprehension?
The apprehension is.
Let them do some action which is not recognized by law.
The bids may be accepted but not be finalized.
No.
Because the act is.
You are preempting something. We send something else.
We
send something else.
There is absolutely nothing.
We have not seen a petition like this.
For a moment, Lordship will kindly take up the act of 17.
You have not even given your bids. Let them take the action.
Section 14 of the act, Lordship will kindly.
Part 3A, Ganguly Learned Council.
For a minute, Lordship will take up the Procurement Act. For a minute. Section 14, subsection.
We will go to the legality later, not now. They have not even done anything. Let them do something.
Lordship will see the non-application of mind is writ large. 14th of March.
We are not interfering with the NIT.
So this is gross illegality, my lord, because.
What is the illegality? In
Rule 3.
Publishing an NIT, it's an illegality.
No, my lord, the terms of the.
They have let them act.
Once
it's all apprehension.
Third party interest will be treated, my lord. That is the difficulty. And it is all done.
Okay, we dismiss it then. Part 3A, Ganguly Learned Council for the petitioner who has put to challenge an NIT dated 21/2020.
No, this is 14th of March 23.
14th of March 2023. The apprehension of the petitioner is that no procedure has been laid down for evaluation of the bids. Full stop. This court is of the opinion that no cause of action has arisen as the petitioner is yet to submit his bid and no evaluation has taken place till now. Full stop. The writ petition is accordingly dismissed at this stage,
at least
giving liberty to the petitioner to approach this court if the need arises. Yes, next.
Your Lordship, I appear for the petitioner in this matter.
Happy?
Yes, Your Lordship. Although slightly in time, we'll figure it out.
2:30.
Your Lordship, this is a writ petition filed seeking enforcement of fundamental rights against both private and state respondents. At the outset, I want to make the submission that the Supreme Court of India, as recently as 3rd of January 2023.
What is your case? Tell us.
Your Lordship, this is basically a matter where a marriage between two consenting adults, which was solemnized under the provisions of the Special Marriage Act, has been declared as invalid and illegal by an extra constitutional authority, which is the respondent number 1 body. This body is basically.
Who are you?
Yes, Your Lordship.
Who are you?
I am. I'm representing petitioners 1, 2, 3, and 4. Petitioner 1 is the wife.
Who are the petitioners?
Petitioner 1 is Monisha Bhorali. He married Joydeep Bhorali. Both of them basically are members of the ST community. They come from 2 different subclans within the community. Now, and similarly, petitioner 3 and 4 are basically a registered body of priests in that particular village in Sipsagar. Respondent 1 and 2 basically are this extra constitutional authority, very similar to.
And 5, 4.
Respondent four
secretary.
onwards are state authorities.
4 is the secretary.
Yes, yes.
No. Respondent petition number 4.
Petition number 4 is basically the
Secretary of
secretary
three.
of the priest union. Petitioner 3 is the president of the priest union.
Your marriage was what, solemnized how?
My marriage was solemnized under the provisions of the Special Marriage Act. If
Where?
you see Annex 1 at page number 39, the certificate of marriage has been annexed under section 13 of the SMA. This was followed by
39.
page 39.
Yes.
Your Lordship, my contention is twofold. Firstly,
So what is your cause of action?
my cause of action is this. If your Lordship will have page number 43 of the record, this is the impugned order. This is basically a notice/communication dated 10th of June 2022, whereby respondent number 1 body has declared my marriage as illegal and invalid.
Will it have any recognition in law, this one?
It does not, and that's precisely my argument.
Then why are you worried?
This authority, this body has basically ostracized me, my entire family. And as a result of which my rights under Article 19, 17 and 21 are under jeopardy.
You see, that may be a civil cause of action.
Your Lordship.
But this is a private body.
Exactly, Your Lordship.
Even if they do not recognize your marriage, their no recognition is not going to make any difference.
Your Lordship, the Supreme Court of India, as recently, like I was just pointing out, while sitting in a constitution bench, has basically held that writ petition, the scope of writ petition now has been enlarged also to private entities insofar as infraction of 19 and 21.
What kind of directions are you seeking?
Your Lordship, as an interim measure, I basically want an immediate stay on this particular order. I want this.
Which order?
The impugned order which has been passed on 10th of
10-6.
June. Yes, 10-6.
This is not even a recognized body.
But the problem is,
private body.
I understand, Your Lordship, but the
What prejudice are you suffering?
The prejudice I'm suffering is that I am not allowed to do anything in my village. One has to appreciate that here we are talking about people in a village, and I can't enter any temple. I have been ostracized, excommunicated to the extent of people in the village not interacting with me. Your Lordships will also appreciate that as recently as
You may have a cause of action, but this is a writ court.
Your Lordship,
this notices by a private party.
Yes,
This
Your
is
Lordship.
not going to affect your rights. Your rights for the marriage has been recognized, has been done by a statute.
Your Lordship, my submission here is that I may be a private body, but my rights under Article 21 are directly getting trampled.
By whom?
By this private body.
By a state authority.
No, by a private body. I agree.
We will not issue a mandamus against this committee.
But Your Lordship, the Supreme Court has held that a mandamus is maintainable against a private body insofar as infraction of 21 is concerned. This is.
Have you made any application to the authorities?
Yes, Your Lordship.
Where?
We have made 2 rounds of applications. If Your Lordship, please, will come at page 62. We have, on 25th of November 2022, we wrote to the local authorities.
Where? Who's the local authority?
1 second, Your Lordship.
62 is Hodo, Deuri, Pujari, Onmelon. No.
The next page, Your Lordship.
63.
No, 62 only, Your Lordship. If you see, at 62, we had addressed a communication to the Superintendent of Police, Sibsagar District. Herein, we had requested the authority to look into the matter, depute police personnel out there, and basically make sure that the ostracization happening does not happen. Nothing was done. Your Lordship.
Is the SPR party?
Yes, Your Lordships. We have made.
Why have you made him by name?
That may have been an inadvertent error.
Made him by name. You don't have anything personal against him.
That's correct, Your Lordship. Your Lordship, it is also important to bear in mind that we had.
You get instructions.
Yes.
R Chaudhary, Senate Counsel for the petitioners. Stop. The petitioners who are 4 in numbers are aggrieved by the lack of action by the respondent authorities against the illegalities meted out to the petitioners by the respondent number 1.
Yes, respondent number 1 and 2, Your Lordships.
Who is the secretary? 1. It is the case of the petitioners that the petition numbers 1 and 2, who are adults, had got their marriage registered under the Special Marriage Act, and in this regard, the office of the marriage officer, Dibrugarh, had issued certificate of marriage dated 14th of March 2022. Full stop. However, comma, the response number 1, which is the committee, is taking measures, is taking measures which are not recognized by law, even to the extent of ostracizing the petitions numbers 1 and 2. Full stop. In this regard, in this regard, representations were filed on behalf of the petitioner to the authorities, including the Superintendent of Police, Shiva Sagar. Even whereafter, no action has been
Your Lordship,
taken.
if I may just add here, we also written a second round of representations. If you
And to other authorities also. Para, issue notice returnable by 4 weeks. Steps for service of notice. No, Sri B. Deori, Leonard State Council accepts notice on behalf of number 4.
3, 4.
3, not 3, 3 is by name.
Yes, Your Lordship. 4, 5, 6.
5, 6,
It is from
7.
necessary party and 9.
6, 7, 7,
7. 7.
6,
8
and 9. 6, 8 and 9. 8 and 9.
It is not necessary.
He has made a party at this moment. 8 also, 8 and 9. 3 adds her. Then Standing Council, WPT and BC. Department accepts notice on behalf of restaurant number 7. Let extra copies of the representation be served upon the Learned Council for the respondents. That steps be taken for service of notice upon the respondent numbers 1, 2, and 3 by registered post with AD. Steps within 2 days. Yes.
Your Lordship, if your Lordships may indulge me in some kind of interim relief, your Lordships to the extent of staying the impugned order and directing the authorities to make sure that
An order by
apology is
the-
issued.
No, not at this stage.
Yes, some customary practices are involved.
Well,
Your Lordship, with regard to respondent number 3, SP necessary party, Your Lordship, let him strike out the name and not echo. Otherwise, that will serve.
Let him serve first. Let us see.
Yes, yes.
Let it come from him.
Obliged, Your Lordship.
Next. Twenty-four, yes.
Matter relates to cancellation of GST registration.
Mm-hmm.
GST was cancelled for non-filing of returns matter.
Yes, well, yes, Mr. Chaudhary.
Lordship, notice my go because the. No, Lordship, there was the time limit, but he didn't fight it for some reason or other. Lordship, that's why I have to take instruction.
Lordship has passed similar order.
That's true, Lordship, all those were, there was some genuine reason, Lordship.
No, we had asked to consider. You take instructions next Monday or Friday, we can have. But we had passed similar order. Why should you deprived of a similar order?
Lordship, let it be on Monday.
Monday, okay.
Item number 24, 59, 60 and 41 are same matter.
24,
59,
59,
60,
60,
and 41 are same matter.
41. On the prayer of Anhad Sri Mishra,
My lord.
RS Mishra, Learned Council for the petitioner. Alag order. Sri B. Chaudhary, Learned Standing Council Finance within bracket taxation. However, please for some time. Full stop. List for motion on Monday. It.
Obliged.
The matter relates to transportation of coal rake, Lordship. That is page 12. Transportation of coal rake.
Transportation of
Coal rake.
coal rack. Yes, what is it?
Annexure 2, Lordship. And similar matters are pending, Lordship. My lord's order is at page 33, Lordship. Annexure 4. Page 33.
Yes, what do you say?
Order is by respondent number 3, presented by Mr. P. Are for 1 and 2 only, Lordship.
P. Sharma, Railways.
No, I am appearing for railway. P. Sharma is for Assam Mineral Development Corporation. Nimpi order is by them.
P. Sharma means
Kanjal.
P. Sharma. Oh, P. Yes. Is he there?
Fine.
You serve him and have it on Friday? It appears that there is a standing concept for Mines and Minerals Development Corporation, namely Sri P. Sharma, whose name, however, has not been reflected in the causative para. That this matter be listed on for motion on Friday date by reflecting the name of Sri P. Sharma, standing council, Mines and Minerals Development Corporation. Yes.
Please.
'26 and '27 are connected.
So the issue which has been raised in this petition is as to whether a best judgment assessment can be completed.
Yes.
Without a best judgment assessment can be completed without there being any powers under the act. Similar powers of best judgment assessment was there under Assam VAT Act, Assam General Sales Tax Act, and under the Assam Income Tax Act also. Now under the GST Act,
there is no such
provision is there. Now, in spite of that, the assessing authority, seizure was made for 3 months. Now, on the basis of that documents, the assessing authority is saying that this pattern must have been there for past also. And from 2017, he has made the assessment. Now, I raised these points before the assessing authority as well as before the appellate authority,
Yes.
and the appellate authority and they are saying that no, this inherent power is there. You will also kindly see, page 110 of the order of assessment, relevant part 110, just before the chart, the bold, the law is. As you also got 110.
110.
110.
Yes.
Just before the chart in the bold, the law is well settled that once it is found that there is a series pattern of suppression or suppression of particular period, or suppression is shipped on the basis of few instances spreading over the different months of a financial year, the testing authority is justified in taking that to be a factor for estimating, calculating the turnover for the whole of the year on the basis of suppression detected. It is also settled that on consideration of the nature and pattern of the maintenance of the accounts, when suppression are found to be continuous process, the same would warrant an addition for omission over the period for which the relevant assessment year. Now, in the appeal, I took the specific ground that there is no power to make the best judgment assessment.
In the statute.
Statute. And they will also see that how it has been dealt with.
By the appellate authority.
By the appellate authority, my lord, it starts with 130 and relevant part at 136. The third paragraph, my lord.
136.
136, my lord. The law is.
What about section 74?
74 is a seizure, my lord. You will also see I've given the section also quoted here. Section 74. 36, my lord.
How is the appellate authority, how is the appellate authority dealt with this?
The appellate authority only is the same, my lord, whatever the assessing authority has given, the same only has quoted, my lord.
Law is well settled.
Law is well settled, the same thing.
Yes,
and the settlement decision of the Madras High Court.
Chaudhary.
If you also permit me, I will give me, lord. Wherein to say that with the best.
Let us have his response.
And Article 265, the Supreme Court has said, not only levy and collection, but the process entire after collection, that is assessment also must be in accordance with law.
That is settled.
So, and the Madras High Court.
He is raising a point that unless the statute gives you the power, you cannot on your own have such assumption. Assumption has to be backed by a statute, which you have in the other.
VAT, GST and income tax also.
Lordship, I have to take instruction.
It is praying for a stay order.
Lordship, let there be no coercive action order, Lord.
That is.
Lordship, may give changes.
Our Dr. Isaraf, Learned Council, Senior Council, assisted by Sri Anand Datta, for the petitioner. The petitioner Both are same, similar?
No, common order, appellate order is common, my lord.
No, there are two petitions.
Petition same, my lord. Petition is same, only different assessment is.
Okay, the petitioner is aggrieved by an order dated 37/2022 passed by the Assistant Commissioner of State Tax, Guwahati Zone B for the period 2018-19. A period change हो जाएगा दूसरा order.
As well as the appellate order.
The aforesaid order to put to challenge in an appeal was also upheld by the appellate authority by order dated 3/2/2023. Full stop. The primary ground of challenge is that the authorities had exercised powers not conferred by law in making in basing their findings on certain assumptions. Full stop. This is the case of the petitioner that unless such assumption can be, unless the statute grants trial of such assumption, it cannot be done, and the same has also not been appreciated by the appellate authority. Full stop. Issue notice returnable by 6 weeks. B. Chaudhary, and it's sending concern finance within bracket taxation. Accepts notice on behalf of all the respondents. Full stop. All the respondents. Full stop. Let extra copies of the writ petition be served upon him by tomorrow. Full stop. Third, the learned counsel for the interim order. Full stop. After hearing, this court is of the opinion that interest of justice would be served if a direction not to take coercive action against the petitioner is passed. Full stop. Accordingly, it is directed that until the returnable date, no coercive action be taken against the petitioner pursuant to the impugned orders.
So the next.
And in the next, the period is
1718.
1718.
I'm obliged, no?
Respondent parties are same, Mr. Sara?
Same.
Yes.
No, this relates to the functioning of the National Company Law Tribunal, Guwahati. Lordship is aware of the structure has been changed, and therefore the section 4919, the central government has to appoint these tribunals, and 11 tribunals were appointed as your lordship. One is the Guwahati bench.
Yes.
And therefore, my lord, the notification itself, which your lordships will see at page 64. You have to give the location.
Yes.
Your lordship.
Serial number 7.
Yes.
NCLT.
Yes.
Guwahati bench.
Yes.
Yes.
In exercise of the powers conferred by subsection 1 of section 419 of the Companies Act, the central government hereby constitutes the following benches of the National Company Law Tribunal mentioned in column 2 of the table below, located at the place mentioned in column 3, and to exercise the jurisdiction over the area mentioned in column 4. So if your lordship sees this column, territorial jurisdiction of the bench is column 4. And Guwahati is at 7, serial 7. It covers, my lord, this Guwahati bench, all the 8 states.
Including Sikkim.
Including Tripura and Sikkim.
Including Sikkim, yes.
Sikkim. So this is the scheme
And then kindly turn to the next document at page 66. Yes. Reference office dated so-and-so 10/12. Corporate affairs order number so-and-so dated 10/10/21. The earlier order, the benches are required to be reconstituted as per the transfer of existing members and postings of newly appointed members. The benches shall attend the matters through video conference. The benches are reconstituted hereby as under. Now, if your lordships kindly have a look at page 67, Guwahati Division Bench, middle of the page. Rohit Kapoor, member judicial. Prashanta Kumar Mohanty, member technical. Thursday and Friday, second half. Now, this gentleman, Rohit Kapoor, if your lordship see the last column, Kolkata. The last column, Kolkata, at the bottom, Rohit Kapoor, member judicial. He is assigned to that Calcutta bench, and he will be there Monday to Wednesday, full day, and Thursday and Friday, first half. So, basically, the tribunal is constituted, judicial member is not there, and your lordships know the legal position that judicial member can singly sit and decide matters, but the technical member cannot. Alone cannot. As your lordships know. But he is there, Rohit Kapoor is there. He's there, but the problem is the court will be functioning only on Thursday and Friday, second half. That also, it is all in violation of the rules, because if your lordship see the rules, the timings are given, first half, second half, all are prescribed. Therefore, I don't understand how this kind of the distribution of because it is now they were doing this through the video. Direction is video conferencing. Therefore, it is only functional on Thursday and Friday, this Guwahati bench. When Rohit Sharma will join the technical member over the video conferencing. The problem is there is a vacancy of judicial member for all these years. And this is how they are trying to do with the result, my lord. The functioning of the tribunal is affected, cases are not disposed, and when they hear the matters, because, for example, the matter we are here, 2,000 pages of the paper book. These matters, as your lordships know, can affect a lot of people in very many ways and with great consequences. So they have to be properly, heard and decided. The hard copy is not available to that gentleman now at Jaipur. And he, when the hearing took place, he was saying that first he said that you file a list of events and dates. Second day, when the matter was again hearing, he even didn't have that. He said, where has it gone? Then it has to be sent from here. This is how, my lord, the hearing is going on for the last so many years, and the judicial member is not there. Therefore, the functioning of this is virtually coming to a close because the technical member simply can't sit and decide anything. Yep. And kindly see the page 70, if your lordship sees. This is 27th June 2022. The NCLT Guwahati bench is hereby reconstituted and shall comprise of NLC second half, NLCT Guwahati bench second half.
it has been reduced to only one half, my lord. Yeah, Dipchan Joshi, member judicial, Prashanta Kumar Mohanty, member technical, he continues to remain. This gentleman is, my lord.
No, Mr. Goswami, don't you think that these are matters essentially administrative in nature?
My lord, it is administrative in spite of.
As a jury, as a court, how can we say? We can see the legality or of an order passed by, but how the bench is being constituted, in what
No,
matter?
I'm not asking for your lordships to constitute benches. Kindly see, your lordships' power under Article 227 is the power of superintendence
that's right.
of tribunal. Now, a tribunal is constituted. There
No,
is
it
a-
is not a case that you come against an order which has been passed by an authority without jurisdiction.
No, I am not coming against an order. I am coming against non-functioning of the tribunal as per law. That is a matter which your lordships will have to see. Nobody else can see that. And such a matter took place in Chennai when, my lord, similar situation arose. Once the court issued notice, they came up immediately on the next date and said that we have appointed. You can't continue a tribunal like this. What is the point in creating a tribunal, my lord, if the judicial member is not there? Who is going to hear the matters? Technical
No, definitely you have a cause of action, but
No,
can
cause
it
of
be-
action, where do I
can it
go?
be agitated in a court
No,
of law?
We have annexed.
Exercising judicial
There is no judicial member, that's the problem. If
no,
the
in exercise of
tribunal like this-
powers of the judicial review, can we go to
Yes,
that
yes,
extent?
this is your lordship jurisdiction entirely. It is a part of your lordship's power under Article 227, so far as superintendence is concerned over a tribunal. And you see the section, article, my lord. Nobody else can do this.
You have not even invoked 227. We will not be so technical, but you have not
Yes.
even invoked 227.
No, that is.
That's we are not going to be there. It's,
Kindly see the provisions for a minute, my lord.
no, that we know, but this petition is not under 227.
My lord, lordships will add that if
But
necessary.
we are finding difficult, to be very frank.
My lord, otherwise I kindly see for 2 years at least.
No, we assume that this is 227. That's
Yes,
not a difficult.
yes, if it is assumed to be.
No, that's we can invoke our powers.
Yes,
But,
yes. Obviously.
powers against
is-
what? Against for constituting or in the manner of a notification by which some duties have been assigned, in which they will function.
No, my lord, that is where the problem lies.
Be difficult, I think.
No, your lordship will have to see this, my lord, the benches of the, I will kindly have a look at the Companies Act, my lord. Section 419.
And whether have you approached the ministry?
Yes, my lord, all the representations are before your lordship.
These are by some practitioner lawyers.
Association is moving. By lawyers appearing there has a
For us.
bigger response.
Association is not before us, to litigant.
We are the petitioner is the affected party whose hearing is going on.
No,
And
no,
kindly
is there any application by the representation by the petitioners?
No, my lord, petitioners are acting through the lawyers. Now, lawyers are the situation which is happening, if your lordships kindly see, it is an absolutely untenable situation. Kindly see what is happening. The paper book is 2,000 pages. And
Now it's for final hearing on 24/3.
no,
We are not going to.
no, it is going on. For 3 days, it has been already heard. But what is the hearing that I want to show your lordships? The paper book is not there at with the judicial member at Jaipur. Therefore, he remains silent. He has no clue. And the technical member is hearing. It is not video so far as he is concerned because the lawyers go there and physical hearing takes place. And the person who is the most crucial person, judicial member, he openly says, we have said that in the petition, the note which was given to him earlier, that also was missing. The para 32, we have mentioned that, and the paper book, which is necessary, my lord. For a matter like this, it's a complicated matter running into 2000 pages. And what kind of a hearing can one visualize, my lord, that the main judicial member is not having the papers before him when the lawyer is arguing? Can you conceive of a hearing like that? And what kind of a judgment it will be?
Well, won't it amount to preempting a authorized body from hearing a matter?
No,
It's at the stage of final hearing.
No, I'm sorry.
If you're aggrieved by the decision, you can come up.
No, that is
There are
not the
also-
point. The point is this, my lord. The point is non-functioning of a tribunal as contemplated under the law. How we have shown. If this is
a matter of convenience and inconvenience. At COVID stage, we also had done video conferencing.
The period is over.
No,
my
no,
lord.
we had done a situation where gone for video.
No, kindly see the difference. What did the courts do in COVID? Your lordships did not come here. We did not come here. There was a link. A lawyer can argue.
No, well, I'm just taking
No,
the
I'm only saying.
I'm just taking the example that a situation may call for different arrangements.
I follow, but kindly see the difference. That's why I'm saying this. Then.
Yes, Mr. Gupta, what do you say?
But the grievance basically is administrative.
Correct.
Non-function, proper functioning of the tribunal.
That's
If I
right.
may point out two provisions of the Companies Act. The petition itself is barred. NCLT cannot be made a party under section 428, the Companies Act.
No, I'm not making.
No,
I'm
no
true.
prosecution,
We are.
no
As a standing counsel for the Union of India, what steps are you taking to
That is what.
make it functional?
You have to take instruction from NCLT whether the
No, not from the NCLT, from ministry.
Ministry.
What steps are you taking to make the NCLT functional in its proper sense?
functional.
Not in a proper
it's not
sense.
functioning.
But we are not fully agreeing to what Mr. Goswami is saying, but a point definitely is there that one, the main member, he is available by e-mode, for which it is difficult to actually go and have a full-fledged hearing. So, and otherwise, that is not the mode that one person will be at Calcutta and here.
No.
You have to appoint persons.
That can be addressed, my lord, even if hearings are to e-mode.
What is your instruction? When are you contemplating to have a full-fledged judicial member for this NCLT Guwahati? No. Have him appointed here, not on Thursdays and Fridays. NCLT is not meant for functioning on 2 days of the week, that to one half.
One half.
This
I'm absolutely
this
surprised.
NCLT is only one for 8 states.
Prayers in the request are not to that effect.
No,
Yes,
we are
yes.
correct. We are going slightly on a different tangent. This NCLT Guwahati is for 8 states. It functions for 2 days a week and that to second half, which is not the purpose of having an NCLT for 8 states. You are under an obligation by the law to have it for functional the whole hog. Now, what steps are you taking? Now, out of here, one, the judicial member, he comes by e-mode. The practical problem. I'm not saying that on the judicial side we are going to do something, but
That effect, my lord, the prayers in the writ petition are for staying the proceedings that are going on.
proceedings,
Proceedings, it cannot go on like this.
Challenges and notifications.
2000 pages of paper book and the
proceedings will not stay.
No, without kindly see the position.
Sorry, proceedings will not stay.
No, your lordship may not stay, but let me go the legal provision and then indicate what is happening at the hearing.
Please.
That is important. Kindly see Rule 8 of the company's rule.
Rule 8.
Yes, and NCLT rules 2016.
2016 rules.
Yes. Rule 8. These are framed under the
This is
company.
that-
Act.
That is under 469 of the Companies
Yes,
Act.
yes. Your lordship knows that.
Rule 8.
469. Rule 8. The tribunal shall hold it's sitting either at its headquarters or at such other place falling within the territorial jurisdiction as it may consider convenient. Territorial jurisdiction, your lordship has seen the notification. Now, sitting hours are prescribed. This is statutory. The sitting hours of the tribunal shall ordinarily be from 10:30 AM to 1 PM and 2 PM to 4:30 PM, subject to any order made by the president. Therefore, my lord, this is a prescribed thing, and your lordships kindly see how the hearing is going on. This is where we are, it's a problem, my lord, because the judicial member is virtually not taking part because he doesn't know what is going on, because it is 2000 pages of thing and they are not having it. Page 32, no? Page 42. Para 32. Now kindly turn to page 32, my lord, for a moment. Page 42, paragraph 32.
42.
Yes. Lordships can't allow hearings of this nature to go on like this, my lord. And it's not just one matter. This is going on for the last 2 years.
42.
And what happened on the 3rd of March, we are narrating now. Interestingly, on 3rd March 23, when the instant matter of the petitioner was taken up, it came to the notice of the petitioners that the judicial member who is physically posted at the Jaipur bench and is conducting the NCLT Guwahati bench proceedings via video conferencing doesn't have any of the files before him during the course of the hearing, and it appears that he is sitting only to fill up the requirement of quorum. In fact, the honorable judicial member himself admitted in video conference that even the note filed by the petitioners in respect of the said cases was not present before the honorable judicial member, in spite of the same being filed online as well as by a physical copy submitted by the petitioners before the honorable tribunal. It is to be stated that without the case file, no proper hearing could be conducted by the honorable judicial member, and any hearing conducted in such circumstances is an improper and illegal hearing having no validity in the eye of law. Eventually, the said note of events filed by the petitioner had to be shared on screen from the office of the learned counsel for the respondents. Hence, in view of the above stated circumstances, it appears that perhaps the honorable judicial member has not been able to exercise his judicial mind for adjudication of the instant case of the petitioners, as he doesn't have the pleadings as well as the voluminous document relied upon by the petitioners before him. Therefore, it is seen that it is only the honorable technical member alone who is able to exercise his judicial mind, as the files, documents pertaining to the case are only before him during the proceedings. Hence, the entire hearing is a farce and in violation of Section 419 of the Companies Act, as per the mandate of law. The subject of company petition number 18 of 21 is required to be heard by a division bench, and hence under law, it presupposes that both the members jointly hear the arguments of the counsel with the case records being placed before them, and upon arguments being closed, apply their minds respectively to the facts of the case and arguments placed, and also peruse the pleadings and documents, and thereafter together take a decision. However, in the instant case, as no proper hearing is being conducted by the honorable judicial member, therefore entire proceeding in respect of this before the honorable Guwahati bench is in complete violation of the law, and therefore the same is without jurisdiction and hence illegal and liable to be set aside by this honorable court. So this is how Miller things are. And we don't know how it was sent, even whether it was sent or not. Even if it was sent without, it is all in display. The councils were noticing and he was admitting that he doesn't have any papers before him. So, my lord, can your lordships allow this kind of a hearing to go on? And for the last 2 years, there is no point creating tribunals like this. And lawyers practicing before the tribunal are representing that have a judicial member here permanently fixed as it is required under the law. And in spite of that, nothing is being done. This happened also in Chennai and Kochi. And the Madras High Court, my lord, was moved and they issued notice. And on the very next day, my lord, they were informed that they have already made the arrangements. You can't allow this kind of a thing to go on like this. What's the point in creating tribunals? Twenty. Next order is also we have given. Council for Union of India from the court that they have already taken steps to make it conform to the requirement of law. So if your lordships will kindly take up Companies Act for a moment. Lordships know it, but let's see. Section 419. 419, that's below the members. Shall be constituted such number of benches as been by the central government, principal bench tribunals at Delhi, and which shall be presided over by the entry. The person of the powers of the tribunal shall be exercisable by its benches consisting of 2 members, out of whom one shall be a judicial member and the other shall be a technical member, provided that it shall be competent for the members of the tribunal authorized in this behalf to function as a bench consisting of a single judicial member and exercise the powers of the tribunal in respect of such class of cases or such manners pertaining to such class of cases as the president may by general or special order specify. That is only given to the judicial member. And then 420 kindly see, this has some relevance for our purpose. The tribunal may, after giving the parties to any proceeding before it a reasonable opportunity of being heard, pass such orders thereon as it thinks fit, So it is a reasonable hearing which is prescribed under 420. And what is happening is something which is inconceivable in a judicial proceeding of this nature. Because, first of all, the requirement is the man in headquarters appointed as a member, judicial and technical, will hear the matters. And within their territory. Now, my lord, if because of the situation you are having video conferencing, you have it from outside. It happened here also, as your lordships know. Some judicial member from Calcutta came and then they functioned here for some time earlier. That was not pre-COVID period. So that happens. That can be done. We have no objection. If the judicial member comes and takes up the matter for 2 days or 3 days consecutively with all the papers available, we have no problem. If that direction, we are happy. But you can't allow this kind of a situation to go on for years together in the name of video conferencing. Everybody has dispensed with video conferencing. Your lordships have, even within the period of lockdown, were attending courts. Your lordships did it, I remember. Therefore, my lord, it is not that I am opposed to video conferencing, but video conferencing cannot, my lord, supply the requirement of these provisions to have a fair hearing, and which can be called a judicial hearing, which is known to law. One man hearing at Jaipur, one man hearing at Guwahati, the other man doesn't know what is, where are the papers, or it is not placed before him that way. Then how do you expect that there is a compliance of these provisions? Your requirement is, under the law, that you have to, the member concerned has to do it within the territorial jurisdiction. Now, if you have a man at Jaipur, he is exercising a power which is not vested in him. You can invest him with that power. He has to come here and exercise. What was happening for high courts or Supreme Court during the period of video conferencing? We do not come, your lordships do not come, but a hearing takes place. But your lordship, suppose there is a vacancy in High Court, another High Court judge cannot hear the matter because it is video conferencing. How can it happen? The same principle was adopted for constitution of bench by these amendments, company tribunals. And at the apex, there is that principal bench. And thereafter, these 11 benches. And it is specifically specified that they will exercise their powers within their territory. As per Rule 8. Your lordship has seen that. Rule 8 is very clear on that.
Yes.
The tribunal shall hold its sitting
of tribunal,
either
yes,
at its
yes.
headquarters or at such other place falling within the territorial jurisdiction as it may consider convenient. And 419 says that within its territory. That territorial connection of a bench is prescribed. This is a mode only. The video conferencing is a mode to exercise the power. It doesn't confer power. The moment you do what you are doing, you are not only, it is exercised as a mode, but you are really conferring a jurisdiction which is not permissible under the law to the member at Jaipur. You can't give him territorial jurisdiction. You can say that you come to Guwahati, hold the matters. That is your distribution of work. I have no problem with that. The gentleman may come here and fix a date, 2-3 days, hear the matter and end it. We are happy with it. But this can't go on like this. It is going to affect us, whoever chooses. And why should it happen when the period is over? All courts are functioning normally. You are not taking your step, doing your duty to make it functional, and you are resorting to video conferencing to bring about a situation which doesn't conform to the requirements of the law. That's the position. And we have said on oath that this is how the hearing is taking place. And why should that go on? The hearing also is peculiar. It started earlier, 10, 11, 22, 10, 11, 29, 22, that is at page 79. And then, my lord, the counsel for the appellant is asked to argue for some time. He argues for some time. Then the respondent is asked to reply. He replies, and then there appears some interim application. Then they say that no, give a reply to that. So this is virtually abandoned, and this interim application reply is being sought. This is how it is going. We have annexed those orders. Page 84 is the order. No, final order has not come because he is being asked to now file a reply to the interim. Page 84.
To have appealed to the
No, it's not a case of
administrative problem.
No, just let me complete. You will argue. This is not register's business. He can't do anything. This is the central government's power and president's right to distribute work. So if you have a vacancy like this for 2 years and you don't take action, where should we go? We have been representing before the authorities. They are not taking any action. And this is the kind of hearing that is taking place. So Rashid can have a look at that page 84. In the midst of the hearing, they are now getting the interim application, and they say that all right, now file and appeal.
Yes.
83, 84, my lord, it is recorded that the arguments were, the matter is taken up through video conference, heard both sides.
Yes,
learned
we have
counsel
read.
position. Page 83.
We have read.
Same. Hearing has not concluded, and now they are being asked to file reply to the interim application. And I have read out what is happening in the hearing. The learned member at Jaipur, unfortunately, he is a silent spectator. So you can't allow this kind of a hearing to go on. Why should the tribunal be not functional? Earlier, Calcutta member came and did hearing matters, I am told.
Okay. Yes.
Not under section 428 of the Companies Act. I may just point out two sections. Companies Act, not 428.
428.
428.
Yes.
Protection of action taken in good faith. No suit, prosecution, or other legal proceedings shall lie against the tribunal, the president, member, officer, or other employee, or against the appellate tribunal, a person, member, officer, or other employees thereof, liquidator, or any other person authorized by the tribunal or the appellate tribunal for discharge of any function under this act in respect of any loss or damage caused or likely to be caused by any act which is in good faith done or intended to be done in person to this. My lord, the NCLT has been made a party here, respond number 3 and 4. My lord, my lord, the prosecution against NCLT barred under section 428. My first submission. And my lord, the second submission was section 431. Companies Act 2013, my lord. May take 31 also. 431. Married.
Vacancy.
Yes. It says, my lord, no act or proceeding of the tribunal or the appellate tribunal shall be questioned or shall be invalid merely on the ground of existence of any vacancy or defect in the constitution of the tribunal or the appellate tribunal as the case may be. But here the prayer portion, the order is directed. This matter, around 20 hearings have already gone by. I've checked the case status, around 20 orders are uploaded in the ministries related to this case. I have checked yesterday, my lord. 20 dates have gone, and when the matter is fixed for final hearing, my lord, now this application is made. The allegations that the tribunal is not functioning properly may be true, my lord. For that, I may have to take instruction. But, my lord, in the prayer, there is no such prayer for seeking direction for proper functioning of the court. That is the prayer, my lord, seeks to stay the order in which they themselves are the petitioner. My lord, after the 3 order, my lord, they can have very well represented before the from the administrative side, the authorities, whatever the grievances are. Application is under 2 to 6, my lord. No violation of fundamental. That the petitioner, my lord, whether the previous representations are there, at the most, your lordship can direct those representations to be considered, my lord. The authorities to whom it is addressed, page 77 representation, that they will, my lord, consider and pass a order. But, my lord, the best can be done, my lord. Page 77 is the representation. Notice may be directed to of the report. Section 428, my lord, NCLT cannot be the part. They are all judicial proceedings.
Now Rohit is not there. Deepchand Joshi is there.
Fundamentally gathered from the submission or the tribunal is not functioning properly. That can be ascertained only their reply is there.
But
20 times the matter was listed, not hearing.
NCLT matters comes up maybe
Matter
for
was-
2010, that doesn't. That what has happened? Hearing it on which next.
no, he is not saying final arguments.
20 times the matter was listed.
Started by
So he's saying 20 times hearing, not final argument.
hearing, the hearing, I understand.
No, there is a difference between final arguments and hearing.
The final.
That is his argument.
Very well, my lord, but I'm just verifying the final hearing of the other started.
That we have seen. We have annexed the. That we have seen. That we have seen. Heard. Sri P.K. Goswami, Senior Counsel. as well as Kegos.
Point out one,
Yes,
428.
yes, yes.
We are not challenging any act on account of any act done by them in discharge of official duty. What does 428 protect? That is the scope of 420. No suit.
And that will take care. That is not applicable. It's not something you have made them parties. That means you're
So
agree
parties
with.
will have to make because the NCLT fixes the roster and
Yes.
central government appoints, there is a vacancy, they should appoint. That is why otherwise I would.
Okay, we'll take care. Sri P.K. Goswami. Let us send a council. Yes.
We are not taking a blanket stay of the hearing. Let him come here with the records available here. 2 or 3 days of hearing will be required. Let him complete the hearing here, the judicial member. We are not running away from the hearing. We want that a fair hearing must take place. How do you explain this kind of a hearing? Where the gentleman there.
The prayer is not that.
No, I am making the intent prayer.
State, my lord, all
Okay,
previous,
we will consider.
previous hearing.
No,
We'll consider. Or
The entire notification is.
I have,
No, I am not doing that. That's why I'm explaining. You are, don't misrepresent me.
Sri P.K. Goswami, Senior Council, as well as Sri K. Goswami. Senior Council, assisted by, who's there? M. Kakoti for the petitioners. The petitioners are the applicants in a matter instituted before the NCLT Guwahati in the year 2021. Full stop. The basic grievance of the petitioner is with regard to the functioning of the branch at Guwahati. Full stop. The contention of the petitioner is that though a notification dated 1st June 2016 was issued by the central government constituting an NCLT at Guwahati for the states of, for 8 numbers of states, including the state of Assam, its functioning has been impaired and is almost in a makeshift arrangement. Full stop. Attention of this court has been drawn to a notification dated 10th October 2021, whereby the bench was constituted by 2 members, one judicial and the other technical, to sit on 2 days of the week, that too in the second half. In the same notification, from the same notification, it appears that the judicial member is also functioning as judicial member for the NCLT Kolkata by sitting at Kolkata, full stop. The said notification has been superseded, is followed by a subsequent notification dated 27 June 2022, whereby there is a change in the judicial member and who was seated at Jaipur, and the matters were to be taken by video conference. Full stop. Para. P.K. Goswami and Senior Council has submitted that Rule 8 of the rules of the National NCLT Rule 2016 framed under Section 469 of the Companies Act is with regard to sitting of the tribunal. Full stop. Rule 9 is with regard to the sitting hours, which shall ordinarily be from 10:30 a.m. to 1 p.m. and 2 p.m. to 4:30 p.m. Full stop. It is the case of the petitioner that they are suffering immense prejudice because of the aforesaid arrangements, as no proper hearings could be held. Full stop. Specific instance has been cited in paragraph 32 of the writ petition with regard to the hearing which had taken place on 3/3/2023, wherein the member judicial had stated that the pleadings were not even before him. Full stop. The Senior Council has also drawn the attention of this court to the provisions of the Companies Act 2013, namely Section 419 regarding benches of the tribunal. And as per Section 419 within bracket 3, the importance of the member judicial has been laid down. Full stop. Section 4 the reference has also been made to Section 420 of the Act, which makes it obligatory on the part of the tribunal to give a reasonable opportunity of hearing to the parties to any proceedings. It is the case of the petitioner that in the present arrangement, no proper opportunity of hearing has been given, causing which is likely to cause immense prejudice to any orders to be passed in the proceedings. Full stop. The petitioners accordingly pray for a direction for proper constitution of the Guwahati bench of the NCLT in accordance with law, where both the members are required to be physically present so that the hearings can be done in a proper manner. Full stop. The petitioners also pray for an interim order to stay the proceeding of CP case number 18 of 2021 and the connected IAs, in which they are the petitioners, full stop, para. The petitioners have also relied upon orders passed by the Honorable High Court of Judicature at Madras, wherein directions were given for filling up the vacant post of the adjudicating authorities in the NCLT benches at Chennai. Full stop. In this regard, 2 orders of the Honorable Madras High Court has been placed. No, not 2 orders. 2 orders.
Yes, the same
have been
proceeding,
placed.
one first time.
Full stop, para. On the other hand, Sri H. Gupta, CGC, has submitted that the prayers made are more to be looked into by the administration and cannot be a part of any exercise of judicial review. Full stop. By drawing the attention of this court to section 428 of the Companies Act of 2013, the CGC has submitted that the instant writ petition may not even be maintainable, as the said section lays down an embargo for filing of suits, prosecution, etc., against the tribunal or tribunal, its members, etc. The CGC has also referred to section 431 of the Act and has contended that the aforesaid section makes it clear that no proceedings would be invalid merely on the ground of existence of vacancies or defect in the constitution of the tribunal. Full stop. Sri Gupta also submits that as per information received by him, in the meantime, 20 hearings have taken place. Full stop. Para. The submissions of Sri Gupta has, however, been refuted on behalf of the petitioners, stating that the provisions of 480 to 428 shall not be applicable, as in the instant case, the NCLT has been made a party, which will not be within the purview and meaning of the said section, as no aspersion or grievance has been made against the tribunal or any of its members, and the grievance is only with regard to having the tribunal to function in the proper manner contemplated by law. Para. As regards the number of hearings, it is clarified that though the matter was listed on a number of occasions, the actual hearings, the final arguments have started only recently. Full stop. Para. Issue notice. Returnable. by 4 weeks. Shri Gupta, H. Gupta, Laliत CGC, accept notice on behalf of respondents. NCLT also.
Notice.
Hmm. 1 and 2. Let extra copies be served upon him by tomorrow. That notice be served upon the respondent numbers 3, 4, as well as the these are pro forma respondents. Pro forma respondent number 5 to 9 by registered post with AD. Full stop. Heard on the interim prayer. Full stop. This court is it is seen that the proceedings before the tribunal was instituted sometime in the year 2021, and the notification of constitution of the bench, which has been put to challenge, was of 10/10/21, which had undergone a change on 27/6/2022. Full stop. The prayers with regard to a bare look at the prayers made in the writ petition would show that except for prayer number 6, C and D, comma, the rest are with regard to the apprehended prejudice which the petitioners may suffer by the present functioning of the tribunal. Full stop. While this court is in agreement with the submission made on behalf of the petitioner that the manner in which the tribunal is presently functioning is not as per the, not strictly in accordance with the act and the rules, comma. The arrangement appears to be made is only temporary in nature, which otherwise is to be looked into by the appropriate authorities. Full stop. The prayers made in the opinion of this court is more to be looked into by the administration, wherein the powers of judicial review may not be strictly applicable. Full stop. This court is also of the view that the proceeding is going on since the year 2021 and has reached the stage of final hearing. And in fact, a look at the orders dated 3/3/2023 would show that the final hearing is already on. Full stop. At this stage, comma. This court has also looked into the two orders of the Honorable High Court of Madras, from which it will reveal that the sole prayer in that proceeding before the High Court was to make the division bench of the NCLT Chennai to operationalize. However, in the instant case, there is a prayer for stay of a proceeding which has been initiated at the instance of the petitioner themselves. Full stop. In that view of the matter, this court is not inclined to pass any interim order of stay. Full stop.
One thing your lordship may kindly, I have already verified. I am not looking for stay of that in a blanket manner. Your lordship may indicate that this grievance can be taken care of. by having the
Yes, yes.
judicial
While the prayer for stay has not been acceded to ACC, the authorities are directed to look into the matter for immediate appointment of a permanent judicial member who and to ensure that the NCLT Guwahati can function properly and in accordance with law on the days and accordance with laws, especially sections Rule 8 and 9 of the rules of 2016.
That your lordship may indicate that this can be done by getting the judicial member from Jaipur here.
Will not say anything. No.
As done earlier, the judicial member from Calcutta came here. And
The authorities are at liberty to explore the option of having the physical presence of the judicial member so that the hearings can be done in a proper manner.
of Jaipur, your lordship. Legal member.
Judicial member.
Of Jaipur. Who is hearing, he may come here. No problem.
That's a judicial member. Member judicial.
Oh, as your lordship.
One more thing, my lord is stating his petition to
No, we are not saying anything.
but my lord,
We are not saying anything.
it's not maintaining.
Where's a judicial review? Next.
May it please your lordship. My lord, I take your lordship to page 50.
50.
50, my lord, it is from the Assistant Register Cooperative Societies to the Deputy Commissioner as regards the possession of a particular plot of land between the two cooperative societies. My lord, then ultimately, the Assistant Register in third paragraph has referred to another order or direction from the Register of Cooperative Societies. That is at page 38. Your lordship will find the cooperative societies, the Register Cooperative Societies findings from second paragraph. It starts at page, my lord, it starts at page 32. 38 is the finding. For the second paragraph, from the above records, it appears Kakini Bahumukhi, it is the private respondent, is not discharging his duties as per provision of such and such. While thereunder, Buragaon SS Limited is the petitioner. Thereby, the society discharges his duties as per provision laid down in such and such. From the above records, I am convinced Buragaon SS is still in possession of the said land and building.
You are Buragaon.
Buragaon.
Then?
Still in possession of the said land and building as rent holder. They shall remain in possession as rent holders and shall pay required rent. The Assistant Registered Cooperative Societies Hojai shall ensure the functioning of Kakini Bahumukhi as per provision of Assam Cooperative Societies 2007. In the event of non-functioning of such and such, the required rent to be paid by Buragaon shall be deposited in the office of Assistant Registrar of Cooperative Society Hojai. The Assistant Registrar of Cooperative Hojai shall keep the amount in form of deposit at call and shall maintain a subsidiary cash book. After ensuring proper functioning of Kakini such and such, the amount shall be released to the society with prior approval of Registrar of Cooperative Society. Buragaon SS Limited shall be in possession as rent holder as alternative arrangement is made by them. So there was a notice, we approached the Assistant Registrar again, and that was the order at page 50. At page 50 and the findings are at page 52. Page 52.
What is your grievance now?
The grievance is that, my lord, because the other party has not approached the Assistant Registrar of Cooperative Societies, he is unable to give any opinion as regards who will be in possession, and he has directed the Deputy Commissioner to take action on them. That is what the
action on the private respondent.
Action on the who will be in possession over the land, because there was a notice issued to me for evicting. That is why, my lord, I am before your lordship that till it is disposed of by the Deputy Commissioner, it is there, my lord, because this letter is from the assistant register to the deputy commissioner, where in the last paragraph it has said, no representative of Kakini Bahumukhi Limited attended on 15/2/22, hence no view of the management of such a search was known. This is for the kind information and necessary action. That is why, my lord, till the deputy commissioner finds anything over that, who will be in position, taking into consideration both the parties, I may not be disposed from my land.
You're in position.
I am in position. That is they have stated, my lord, at page 52 top, the Buragaon Access Limited is regular paying land revenue to the government, and they all denied vacating the possession of the Kakini Bahumukhi. Their joint written deposition is enclosed in Annex 3. Page 52, first paragraph, last 3 lines.
Your prayer is otherwise, prayer is different.
My prayer is that much because, my lord.
No, your prayer at page 16 is a different prayer. You say that you have pray for a direction for allotment of 8 acres of land.
My lord, we have also said that because this land was previously by another cooperative societies, which become defunct. So when it became defunct, we also tried to pay the liability.
No, you are praying for an allotment of the land.
Allotment of the land.
Now you are saying that there is a proceeding between you and the private respondent.
Private
Till that proceeding is disposed of, the possession which you are holding should be allowed to be continued.
Till the deputy commissioner takes any action over them. Because the assistant register said that they are not happy.
But
We are not fully convinced.
Lordship, but otherwise, your lordship, initially that particular land belongs to Kaki Mobile Samiti.
It becomes
It has been defunct and it has been liquidated. And subsequently, the respondent number 6, they bought that particular plot of land by executing a sale deed, which was registered on 5/3/2001.
Sale deed from whom?
From the liquidator.
Okay.
From the liquidator.
Correct.
And since then, the present petitioners, they are possessing the land as a tenant.
From the?
From the respondent number 6.
Okay. And 6
So
is
there's a
still.
dispute between landlord and a tenant as on today, your lordship.
The register, because both are cooperative societies, so register.
The company, in a liquidation proceedings, the private respondent had purchased the property and he is the tenant.
Yes.
Now there is a dispute between him and the.
Yes, in fact, your lordship, the private respondent number 6, they have filed a writ petition that is 7/7/2022, that is pending.
Remember something like this is. When is that petition coming?
Lordship, in that particular case, I have received my para-wise comment and I will be filing my.
No, when is it coming? When is the next date?
Lordship, month of April, because it was listed 2 weeks back. I have sought for some adjournment. Your lordship.
PPK or Chaudhary, counsel for the petitioner, who by means of this petition has prayed for allotment of land measuring 8 bigha 13 lecher covered by Dag number 29 under Kaki Mouza of Runi Pukhuri village in the district of Nagaon. Full stop. It is the case of the petitioner that the petitioner is in dispute with the private respondent number 6 with regard to the said land, which is presently looked after by the deputy commissioner. And the said dispute is before the deputy commissioner Nagaon. Full stop. Para. The G Board Land Planning Council Corporation Department, however, submits that a writ petition has already been filed by the respondent number 6.
Who is the landlord?
Who is the landlord of the property in question? And the said writ petition is number WPC
7977 of 22.
7977 of 2020. Full stop. Para. Issue notice returnable by 4 weeks. 3G Board Planning Council Corporation Department accepts notice on behalf of respondent number
1, 3 and 5.
1, 3 and 5. Revenue Madam? Okay, that's a ঠিক করে নাও, motion করে। J. Hazarika Leonard, Planning Council, Revenue, accepts notice on behalf of respondent number 2. B. Deori for respondent number 4. Let extra copies be served upon the learned council for the respondents. Let the respondent number 6 be served by registered post to TD. Steps within 2 days. Full stop. List along with WPC
7977
79
of 2000.
2002 para till the returnable date, comma status quo with regard to the land and question be maintained. Names of MSG Hazarika Leonard, Planning Council revenue be reflected in the cause list. It was first motion, no? There are 10 more motions remaining. Rest, it is, we cannot do. Among these 10, we will take up the urgent matters where interim orders, interim prayers are also there. If possible, we'll take all the 10. At least the urgent matters will have. No, today itself, urgent will have today. Those having interim orders, interim prayers.
Others would follow.
Tomorrow. Which is senior counsel, sir, Mr. Gupta? Motion.
I am other side.
You have some interim prayer?
Interim prayer is there, but if you lordship.
I don't think there is any interim.
No, there is interim prayer is there.
That means there is.
The prayer is there.
But we not, if you lordship convenience, it is not possible on Monday.
No, it is possible. We can sit for some time. We sat late. We can finish the motion, but we'll prefer where interim orders are.
Truly speaking, so far interim is concerned, there is nothing.
Let me speak, before that, why you have.
Unless it is so urgent, why should your lordship?
And which other cases, if there is prayer for interim relief? As a hawk you have, and any more? Interim prayer is there. If those are urgent, we'll have it, no problem. We'll have it serially, Mr. Das.
I have a motion, my lord. Next item.
Interim is there.
Interim.
Yes, next. Aren't you fed up of fish?
I'm sorry.
Aren't you fed up of fish?
It's a court.
Fishery either this side or that side.
Not fishery.
That's
It's a
not
court.
proper. Sir.
It's a court.
You should have something else also.
It is a court society's case, not a division of two court society, my lord.
Mr. Mannan, you're for whom? Why for motion?
Number 8.
There's a you're on caveat.
Yes, we are at caveat.
Yes.
My lord, we are the Soreshwar Mean Samavaya Committee Limited.
We could have completed. One matter took long time actually. The NCLT matter.
Yes.
Yes, next.
My lord, at page 37, there was a meeting call for division of this society.
Who are you?
We are a registered Soreshwar Mean Samavaya Committee Limited. Now there is a fight between Soreshwar and Godadhar, which my learned friend is appearing.
What is his name? Godadhar.
Godadhar. At page 37, there was a meeting called for division of petitioner society at page 37. And at page 43, an order was passed by in charge district deputy registrar, my lord, that you can divide, but there has to be compliance of section 13. If you want to divide, you can divide, but there has to be compliance. And accordingly, at 46, there was a report of the inspector to dissolve.
By complying section 13.
Yes. Dissolve.
Hmm.
Now thereafter,
At 40, what dissolution is where?
at page 46,
Dissolution.
that is report given for dissolve, report given by the inspector to dissolve. Now at page 49, the new society, this Godador, at page 49, kindly be seen, my lord, the order that was kept in abeyance at page 49 by the in charge assistant register at page 49.
Yes.
Registration of Godador means by committee with reference to so and so. Therefore, the registration of newly created means by committee, namely Godador means by committee limited, is kept in abeyance until instruction comes from the district deputy registrar of code society. But there has to be some compliance. That's why they have kept in, even then there, what has happened? There was,
Are its registration kept in abeyance?
yes, it was kept in at page 51. This was put to challenge before this honorable court at page 51. This was kept in challenge. This was put to challenge before the learned single judge by Godador. Godador mean at page 51.
WPC?
WPC 242 of 2014.
By Godador.
By Godador. Now,
Again 1611.
yes. Page 53, my lord, it was disposed of by this honorable court directing the register of at page 53, kindly be seen, my lord. Last. In view of a writ petition and dispose of directing the register of court society to resolve the issue raised in the writ petition, express positive, but not later than, so till then the petitioner shall not be deprived from right of fishing the jurisdiction. So right of fishery they will have.
Matter sent to registrar.
Yes.
Remand.
Yes. Now, at page 54.
Yes.
Registered Cooperative Society has passed an order, my lord. That is on 1928. That section 13(1) has to be followed. At page 55, kindly see, my lord. Order passed by Register of Cooperative Society as
This is after the remand.
yes, after the High Court's passed the remand.
Remand was of, what was the date? 21.
Yes.
21/14.
21/2014.
Okay.
And accordingly, an appeal was filed on 31/12/2013. And accordingly, this was the order which was passed.
19.
Yes, at 55.
54.
55, kindly see the operative portion of the order. After hearing and scrutiny of all the relevant record, it is observed that when a court divides itself into two cooperative society, societies shall have to fulfill the provision of section 13(1) to 6 of Assam Code. But here in the instant is seen the required formality were not observed and as such need to be reprocessed. In view of district deputy registrar cooperative society to start reprocess or division, so till then status quo shall be maintained. This was the direction in pursuant to order passed by the register.
In view of the
Now thereafter, my lord.
Division.
Yes. Now there are some proceeding I will not trouble your lordship. Then at 78, 72, my lord. That is in 5/9/2016, my lord.
No, so far as Godador's problem, their division is concerned.
Yes.
How are you connected?
Because this initially it was one.
You Godador was a part of you.
Yes. Forester was the main. They want to divide because certain areas fall under BTD and some non-BTD area. Now certain BTD areas member also have resigned. Certain resigned, they doesn't want also. So at page 72. 72, my lord. Reversed in 2016, my lord. AGM was held.
Of your
Yes, society, our society. AGM was held. Kindly see on the first paragraph, resolution number C, COP. Today, this annual general meeting, out of total number of members present, 13 of members shifted to Kokra district of BTA have voluntarily applied for withdrawal of membership along with nominee from society. state members to the application withdrawal as specifically stated, they would not make any claim whatsoever from society from today. The general body, after thoroughly accepted the proposal, directed the executive committee to immediately delete their name from the membership of the society. Now at page 73, 1, 2, 3. From the formation of society, Sareswa means the same is within the jurisdiction of Dhubri district and a sitting lessee of 3 fisheries so and so. Society was registered under old so and so, and all the village registered society falls under the old so and so. Other important reason is that those members who hails from BT had voluntarily withdrawn from membership of society, which is stated in resolution. Since no member is left from BT, so there is no question of division. So there was no question of division. Resolution was taken, which this proceeding was sent at page 78 to the assistant registrar, my lord. At page 78.
What is your grievance?
My grievance is that there is no question of any division, my lord. When resolution has been adopted, and there is one writ petition which has been filed, and that particular, my lord, already that matter is pending. When the AGM was held, resolution was taken. There is no question of any bifurcation. This was sent to the assistant registrar at page 78. 78, they kept it. So your lordship knows under one provision, under section 45, it's dim within 15 days. If you don't take it, it is dim. Now, my lord, even then there was a joint meeting. After this joint meeting, the authority said that or have a joint meeting for bifurcation. Now, this was put to challenge before this honorable court at page 101, and the matter is pending. And there is a stay order passed by this court. Kindly see 101.
Matter of bifurcation is the
Yes,
is at the
they
stage.
asked for joint meeting for bifurcation, we came to this honorable court. And at page 101, kindly see, my lord.
The joint meeting has been stayed.
Both the joint meeting, 18-1-2017,
That means
13-1.
joint meeting was for bifurcation.
For
That has been
bifurcation, it has been stayed.
stayed by High Court.
Yes. Read petition
Now, what
849.
do you want? Tell us.
If were by, where is it now? We challenging 110. In spite of the order that is pending, my lord, there is an order which has been passed by the assistant additional registrar of Cooperative Society.
Yes.
He takes a decision. Now he takes a decision. He said no. There can be a bifurcation. So kindly see, my lord, this order has been passed. How can he pass this order when this matter is pending before this honorable court?
What is this? This is your impute order.
Yes.
110.
Yes. 3rd of December 2022. When we came to know only in the month of February, my lord. When the matter came up, that matter came up. When this the matter which was stayed, my lord, then they produced one letter before this court of this order. Then we said that we are not aware of it. So we will be, liberty should be given to challenge it. And accordingly, we are challenging this. Our whole contention is that, my lord, when the matter is pending for disposal by this honorable court, where is the question of passing this order? 3rd of December 2022.
Yes, Mr.
There are another aspect of the matter.
No, if what City
No,
Council
that-
says, that if the matter is pending consideration by this court,
That-
why you preempt by passing 3/12/2022?
Two things, your lord. First and foremost, initially, there was a order for division. My learned friend has submitted, I'll point, because there's another round of litigation going on. That case up to lordship appeal also. The rate appeal, the court has also directed what to do. If since they have filed the writ petition, since the first date has come up, file the affidavit, but I have the orders, I'll provide you. What has happened? There are two litigations, two round of, one by them, one by us. Those orders which were against them, they filed a writ petition. Against us, they filed. And these orders, your lordship, what has happened? In all these writ petitions, there was one order that division was not made. Therefore, those who are in the BTD area will continue in the BTD area, and those who are outside the BTD continue outside the BTD. It is an admitted fact that
that particular Samavai Committee where my line seniors there. It is the Samavai Committee which was started in 1975. At that time, it was in Ruposi. They have annexed that certificate. That time it was together. Later on, it has become separate. There is a subsequent registration of that particular society in BTAD. That was in 2015. That they have not annexed. I'll give a copy of it. Then, Your Lordship, what has happened? We have also registered Godadhar after the division. Godadhar has registered as non-BTAD and this particular as BTAD. Now, the area in concern is that we are running in BTAD, we are running outside BTAD, they are inside BTAD. All the orders passed by the Honorable Court, even the division bench, directed that you have demarcation, forget about whatever demarcation it will come, but both the parties, BTAD, they will, and non-BTAD, we will continue. That is basically the case. Now, with regard to demarcation and the other part, court has not interfered at all. There was no interference by the court. Court has all throughout directed that demarcation should be done. Demarcation. There were so many litigations in between. I think 5 or 6 cases have been filed in between these parties all throughout. So, Your Lordship, those cases were tagged together, have not yet been finally decided. This case, Your Lordship, the order was passed in December 2022, 3rd of December, 4 months back. And Your Lordship, this whatever order has been ordered and challenged has already been I think complied with. And Your Lordship, what has happened? I'll just is clearly indicated in their own meetings, in their own general meetings. I don't know, executive committee meetings. They don't know. Here it was specifically. Here, Your Lordship, in their meeting in 2018 itself, they agreed. In today's, I'll provide this general meeting. It was unanimously resolved that after the division of the Saraswar Mean Samavai Committee into Godadhar so and so in the non-BTAD area, there is no society in the BTAD area, and as such, Saraswar means should remain in the BTAD. So their own resolution that is there. And subsequently, another executive meeting was there, which they said in their resolution 3. I'll provide both of this. In today's meeting, it was decided and resolved by the executive committee of Saraswar Mean Samavai that from today, it will not interfere in any matter in the area of operation of Godadhar Mean Samavai Committee, and our area of operation will be limited to BTAD. So they have themselves. Now, demarcation may not have been done, Your Lord. There was no order by any of these writ petitions or as well as the writ appeal that you don't go for demarcation. Only issue was who will be running where and where. That has been decided, and the court has all throughout said, the division bench order, all throughout said that the orders division bench in the writ appeals. This is the
Which order?
the writ appeal 382.
You need some fresh.
Yes,
Because what happened, Your Lordship?
You need some fresh application, mind.
My prayer, Your
We'll
Lordship.
have this tomorrow.
Lordship can do one.
We'll do it to have it tomorrow.
Yes, and also Lordship can
Tomorrow,
take it with the other.
without having a fresh mind, we'll not be able to.
I have no problem.
Tomorrow.
But only thing, Your Lordship, the other writ petition, if it is tagged together, then all these facts are there because these
By
are all.
tomorrow, it may not be possible. Otherwise, we'd have done. Tomorrow, we'll hear this.
I have no objection, but if Your Lordship can tag it and make it day after two, subject to my learned senior.
Tomorrow will be, Your Lordship will hear this tomorrow. Thereafter, Your Lordship will take a call. Your Lordship will hear this.
Because those matters, writ appeal is
Yes,
also.
Sleep, huh? By sleep. Motion tomorrow. I think tomorrow we'll do. Mr. Saraf tomorrow. Rest of the motions tomorrow.
Accommodation in later.
Yes, we'll do.
We have got some matters.
No problem, no
My
problem.
case will have DTA, the willful defaulter, so I don't want to do it today also.
Which one will defaulter?
Tomorrow.
The willful devoted, that's why, my lord. He want application of mine from every side.
And application mine, he always.
Who is willful defaulter?
My lord,
Mr. Rasta?
Mr. He declared me the willful defaulter, madam.
So let it come on Monday, my lord.
Monday, item number? Which item?
55 supplement.
50 paucity of time as agreed to by Monday. Mr. Kaur, motion?
58 supplement.
Tomorrow. Rest, unless you have some other prayer, we'll have it tomorrow. Motion matters.
My lord, in item number 32, my lord, the interim order may be correct. Item number 32, my lord.
If there is a interim
My-
order,
That may be correct.
side over, huh? Possibility of time, on 2 weeks, interim order.
Much.